Item 2.
Petitioners are acquitted for all the offenses.
Item 3.
I have enhanced the, maintain the conviction and enhance the fine amount to 25,000 each, and invoked 357 CRPC for the purpose of disbursement of the compensation to the accused.
Item 4.
Partly allowed the appeal.
Item 5.
Partly allowed the revision.
Item 6.
Petitioners are acquitted from all your charges.
Item 7.
I have modified the sentence by maintaining the conviction, and the sentence is modified to 6-month RI.
Item 8.
The entire 2CC proceeding number 9 of 2023 are quashed.
Item 9.
With certain observation and granting liberty, I dispose of the revision.
Item 10.
I have dismissed the petition. Yes. Yes.
My lords, may I mention on the virtual mode, lords?
2 o'clock.
2 o'clock.
Today 2 o'clock.
23rd.
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 Parties are
Ready for
okay.
90.
Next.
Pardon?
94 item. 94.
94. Yes.
Pardon, the mention lordship, the fresh admission or alternation of a
Give the
charge.
memo. Give the memo.
Yes, sir.
Give all memos. We will examine those memos. 18 parties are there. 12 o'clock. 12 o'clock, I think.
But
12 o'clock. Yes. Next.
my lord,
Item 61 and 62. And 10
Fresh matters? Yes.
my lord, mediation is already completed. Joint affidavit also given. Waiting
Where are
for
they?
my lord.
Item?
This is serial MC 405.
Take it up. Mediation successful.
Mediation are already completed.
Mediation successful.
My lord.
Revision. It will come. All now this assignment is given to this court. We'll see how we will list it. All the matter. Very old matter. Matter which years?
22.
22. Just wait. Matters of 2005 are pending here. You're talking about 22. Merely because you mentioned, I can't take it up like that. We'll see this. Serially, we'll see. Okay.
pardon, Lordship's item 13, fresh matter, no interim application. I have to take instruction with regard to the status of trial. Any day next week.
30. Adjourn.
1-3, your Lordships. 1-3.
Lordship.
Sorry, 1.
Oh, bless you.
Yes. 101. Yes. 101 adjourn.
Lordship item,
But next week,
Lordship item 22.
22.
We are seeking for an adjournment any day within
Fresh
this week.
matter or after
Fresh admission, Lordship.
fresh admission. 22 also adjourn. Yes. Come on.
22.
Fresh matter. Afternoon, bring the other side. Nothing.
The number is not visible, just long distance.
No, I can't because the market will see when the matter is called up. Okay. Here, come. Start.
Let's may I mention, my lords?
11.
My lords, may I mention one virtual mode, my lords?
Some mentioning online. Yes.
My lords, when say fresh matter, my lords, registered on the 22nd of April this year, my lords. My lords, may list it tomorrow. I'll physically appear, lordships. It's a 482 application, lordships.
Fresh matter.
Fresh
What is
matter,
the what is the
Lords,
urgency?
that the matter is pending since last 11 years. Charges have been framed. My lords, I have no role absolutely, my lords. I will demonstrate, my lords. May give me physical opportunity tomorrow. I'll appear in person and argue. The
I only see that the urgency is you are physically present.
My lords,
Tomorrow.
obliged, lords. Grateful.
My lord,
Grateful.
my lord, I am at VC Sammal.
Yes.
Like to mention,
Yes.
I would like to mention a case under section 482 CRPC for quashing of FIR.
Yes. What is the urgency?
Urgency is, my lord, there are 8 number of petitioners apart from some others against whom an FIR has been registered in respect of an
What is
loan.
the urgency? What is the urgency you tell for mentioning so much time? What?
My lord, all the petitioners are more than 16 years, lady and ST. They had taken some loans under self-help group. And
I am not on merit, sir. Merit, you may be having good case. What is the urgency? Pressing need to be heard early.
There is a possibility of arrest and harassment, my lord. They are old.
Then for that 438 is there, not 482.
My lord,
438 you have okay, you give the memo. You give the memo, we'll see. Give the memo.
I am at VC, my lord.
You have to give the memo, sir. Otherwise, how it will be listed? You have to give the memo. Please send someone. In the afternoon, you give the memo. We'll see.
Online, my lord.
Send your instructing counsel, whoever is there in the High Court, you send it. Okay? Yes. Yes.
Item 11, my lord.
Yes.
My senior has given me copy of affidavit on last week only. My IO is not available. Your lordship will grant me some more time because we have to verify whether schedule offense exists or not. On 8th only I received the copy, my lord,
Yes, sir.
and IO is not available.
No, the last occasion.
Because the predicating offense goes, everything goes.
That's true.
what he said.
That's true. That's true, my lord. But what I found from because the IO is not available, I don't have the records, my lord. What I found, my lord, from the Supreme Court order, the petitioner number 2 had challenged whether I have to verify whether there are other schedule offenses are pending or not. Only that only we have to verify.
Mr. Agrawal, the counsel for the petitioner submits that he would seek instruction from the department regarding the status of the predicating offense, predicating or schedule offenses. Leave the matter.
Now, my senior has filed an affidavit that the schedule, only that part is to be verified. Obliged.
Well, may I please your lordship? And in this case, the petitioners have approached this honorable court
Yes.
under section 482 CRPC to quash the proceeding pending against them in the court of the learned SDGM Khorda, my lord, on the ground that on the basis of an FIR lodged by PW1, my lord, Jonkia PS case number 75 was registered.
What is your ground?
Ground is husband and father-in-law, they faced trial before the learned trial court and since
Husband and father-in-law.
father-in-law, they faced trial.
They got acquitted.
Got acquitted since none of the prosecution witnesses, including
Who are
the
you?
My lord, I am the mother-in-law and nonando.
Yes, Mr. Ragada?
But that's true, my lord.
Yes.
But in fact, my lord, they made the informant and opposite party number 2, my lord. But that, my lord,
We'll issue notice then.
my lord.
What, the offense is 490.
Ultimately, my lord, the husband and the father-in-law acquitted, my lord. Nobody supported the case.
Then
Notice
what remains?
Notice out.
498, yeah?
No, 306 is there.
306.
That's it, 306.
498 and 306.
Prime allegation is against the husband.
Husband and all of the, but the husband was sole
Why
responsible.
these people were absconding?
Exactly, my lord.
My lord, in the judgment, the learned trial court has mentioned that during investigation, the IO could not trace them out and file charge sheet.
How will they trace if you are evaporated? Your son, your husband, everybody got arrested and you evaporated. Anyway,
My lord,
issue notice to the opposite party number 2. Opposite party number 2, returnable transfer. Mr. Ragada accept notice for sale. Then counsel for the petitioner submits that the FIR, the PS case number so and so was under section so and so was registered against the husband of opposite party. Husband of
Of the deceased.
father-in-law,
and the entire family member. The husband and the father-in-law of the deceased face the trial and they have already been acquitted by the trial court.
my lord.
This is a petition filed by the mother-in-law and the
Sister-in-law.
sister-in-law. Tapare issue notice. Call the father of the deceased. Let us see. We'll see. Returnable.
Oblige, my lord.
Item 14.
Yes. Yes.
I am not facing the petition against petition number 1. Petition number 1 is the principal accused. I am not facing the petition against him.
Okay.
And as far as petition number 2 and 3,
Yes.
they are parents of the petition number 1, who is the principal accused.
Okay.
But petitioners challenge order taking cognizance of the annexure 2 at page.
What are the allegations against?
My lord, charge sheet has already been submitted against me under magistrate tribunal office.
Charge sheet देखी थी, charge sheet देखी थी. Charge sheet.
Where is the copy of charge sheet?
देखी ना, charge sheet देना थी. आउ,
And,
they may added
The
the,
matrimonial list. I am
certified copy.
by filing. I am just issuing notice.
and also they have not added the informant as a operator too.
That's the minimum.
Because it is arranging, though it is
Complaint
arranged
case.
out of the complaint case, but subsequently it is registered as GI.
It's all right, but in a matrimonial dispute, the wife, learned counsel for the petitioner submits that at the outset, learned counsel for the petitioner submits that he doesn't want to press the present petition insofar as petition number 1 is concerned. He seeks leave of this court to implead the informant of this case as opposite party number 2. The permission is granted. He may implead opposite party number 2 during the course of the day, countersigned by so and so. Issue notice to the opposite party.
Interim application.
Issue notice on interim application. Yes, Mr. Ragada, it is matrimonial issue. Proceeding arising out of so and so, qua the petition number 2 and 3 are stayed till the next date again.
Okay.
Item 15.
Why don't you settle it? Try and settle it.
Yes, sir.
Yes,
Item 15.
15.
I will add here.
Yes, here. Opposite party number 2. Yes. Yes.
And soon
But then what I am asking is, if the charge has been framed, you are assailing that, then the right course would be to file a revision petition.
Then both be actually, in fact, challenging my discharge along with it. I do contemplate it at that point of time, but since I am challenging the discharge initial order with the leave of this honorable court as well as discharge, so I have come 82 and 401. Both are-
Anyway, what are the offenses?
Correct. Offenses are on section 13(1)(c), D, and 420, 379, 468, 409, 400. It's a Mullugudy mines that illegal mining operation. In brief, I can put it this way.
PC Act is also there.
Yes, ma'am. there are accused number 1 to 16 are government servants and 17 to onward are the private persons. The brief fact is this one.
But you are Vijay Kumar Mahanti.
Yes.
Who are you?
I was a mining list and my lease was granted in the year 1980.
You are 85-year-old.
Yes. 83 lease was granted in my place. It was valid for 20 years. Now, when I'm trading health, I granted a power of attorney.
You move application to 205. I'm giving you.
No, I am already on break. I'm already on break. No, what I'm saying is the entire case of the prosecution is being taken on its face value very appropriately. I'm not going to further disclose. The case is of the prosecution is that I am admittedly a mining lease holder. My mining lease was valid up to 2003. Because of my failing health, I executed a power of attorney in favor of Deepak Gupta. Deepak Gupta, however, mined it from the other lands, not from the mining leasehold area of mine. He actually takes minerals from government land and other leasehold area. Now I have been added as an accused.
Vicarious liability.
Now, I am not a single grain from my mining leasehold area.
Those things will be extracted in the trial. How can I at this stage will give an opinion that nothing is extracted from your...
They themselves say that not a single grain of my mineral has been extracted from my leasehold.
Where do they say? Show me.
They say at the FIR, your lordship page.
No, forget about FIR. In which charge sheet? You show me.
In the charge sheet, they have accepted that. I am looking from FIR and now I am giving a joint verification report and lordship has paid.
All these things has to be proved on record, sir.
These are based on record. This is a part of the record.
But all these things are proved on record.
Yes, madam. They have digged out.
How can it be proved unless it is put to trial?
They have relied upon this document. I am not. This is not my document. It's a charge sheet document.
The problem is you want me to go into the tidbits of every document and conduct a mini trial here.
I'm not lordship attention to tidbit. I'm just drawing a lordship attention to one document.
Show me one document.
That page is 100.
Yes. 100?
150.
150.
Yes.
Okay.
During joint verification of illegal mining.
Yes, I'm there. Exactly.
Joint verification of illegal mining activity carried out by BK Mohanty in Hon'Ble Reserve Forest and Village Forest and Non-Forest area in Hon'Ble. During joint verification of illegal mining activity carried out by BK Mohanty in the village inside the Hon'Ble Reserve Forest by mining and forest revenue officer, it was noticed that the RCC pillar mentioned in the BK has posted around the said area very bad. Some security personnel were found mining area where I would told regarding the mining area of BK Mohanty on verification of the following observations are made and irregularities. The reserve pillars have been shifted and mining carried out even inside the Hon'Ble Reserve Forest illegal. Mining activity have completely been done outside the leasehold area of Sri BK Mohanty. The mined out area, domed area, crosser area, stockyard were surveyed and cross-checked in the village 6 with GPS reading of the above illegal mining area were taken and enclosed. One map has been prepared and enclosed herewith for reference, mentioning the plot number of the village 16167. It is also ascertained that no mining operation
who has given it?
Well, all the forest official.
How many of these people are accused along with you?
These people are not.
Officials are
not
hand in glove with you.
No, these officials who are
maybe officials are hand in glove.
Those are.
How do I know that this document is procured or not?
No, this is part of the your lordship can ask this question if it is not.
Yes, Mr. Ragada.
He
relies upon some document to say that no mining activity.
Vigilance case, my lord. Not
my lord, I am appearing as a special counsel on behalf of the vigilance.
Yes, sir. He is relying upon a document. It is a joint verification report which indicates that in his mining area, no activity was carried out.
It's not correct. My lord, why I am saying, my lord, kindly see, I think this case has come not less than 30 times to High Court. It is the greatest mining scam of the state, Hon'Ble mining scam, and now ED investigation is going on. 29 accused persons, and this Vijay Kumar Mahanti, Lord, he is the principal, one of the principal accused in this case, because he had got a lease from the government whose period has expired. Then he appointed a power of attorney holder, Mr. Deepak Gupta, through whom he excavated illegally mining ores and made the government to put a loss of.
But this report indicates that in his area nothing has happened.
No, his area and another adjoining area, Jagdish Mishra, both the leasehold areas are adjacent. So they excavated from the adjoining area lease. Now question is, my lord, pursuant to direction of this honorable court, trial is going on. There are 150 accused persons, 51 accused persons already examined. My lord, 55,000 pages documents. And if your lordship will see in the charge sheet, on each page, Mr. Vijay Kumar Mahanti's name will appear. If your lordship will look to the charge sheet dated 31st/12/2013.
Yes, the problem is 2017 order. Much water has flown by now. Many
That's
witnesses
right.
are examined. I can't scuttle the trial at this stage by on the at the instance of you.
I begin it by saying that.
But he had already filed a miscase to discharge him. That was rejected.
It is according to me not safe for giving any interference.
I myself saying that their trial has been proceeded about some witnesses in the exam. Or not.
How can he be? Because if he is acquitted, that's a different thing.
What I am saying, my lords, what I'm saying is that their own allegation in the affair and the charge sheet. I am not going to any other things. If, my lord,
Why have you waited from 2017 to 2023?
I am an old man, conduct.
That will not see. See,
and I have come up
giving
here.
any opinion at your instance is tantamounting to interfering in the ongoing trial,
No, my lord.
which I am not going to do.
No, I am not saying that your lordship to look into.
Melody, your lordship may also look page 173 of this brief. He had already in 2017 challenged this, my lord. Your lordships rejected that case and permitted him to refile again. Then he filed in 23 after 5-6 years. This is how. So at this stage, can it be said there is no prima facie case for trial?
And my lord,
Let him be acquitted. I have nothing to say.
It is saying that the mining as operation has been done in Jagdish Mishra's case. Jagdish Mishra's leasehold area.
Yeah, what come to 173, page 173. How will you explain it? And you know when the cases are withdrawn, you know that.
That is, I have not suppressed anything. I have stated.
That's right.
Even
it is expected from you that you will not suppress. But how will you get out of it?
My lord, I leave it this way because this is a complete abuse of process of law and a 85-year-old man without the evidence. I am not saying that.
On 5/6/2017, charges were framed. You filed a criminal miscase in 2017.
I can advise.
And on 24/11/2017, after arguing for a long, you withdrew and took liberty. Thereafter, in 23, you are filing again. And you want that I should interfere at this stage, despite the fact that witnesses have already been examined.
I can say only this because of a high-profile case with the high-sounding. Nobody is ready to look into the going to
a low-profile case where you appear will become a high-profile. What to do?
Because this is what is happening.
Sorry, I am not interfering. Shall I dismiss it or leave it like that?
I leave it there.
Do you need an elaborate order?
No. That's not interpretation.
In view of the fact that the charges have already been framed on 5/6/2017 and trial is proceeding at the pace it is expected. At this stage, I am not inclined to interfere in this matter. hence the matter is disposed of.
At least they were granting liberty, looking at my age.
At this stage, at this stage, Mr. submits that the petitioner is 85-year-old man, and taking into consideration the allegation level against him, the ongoing trial is an ordeal for his client. Therefore, he seeks permission of this court to liberty from this court to move appropriate application under section 205 CRPC for personal exemption. If such application is moved, the same shall be considered, keeping in view the age of the petitioner and the age of the petitioner and the allegation made against him. With this liberty, the petitioner.
Your Lordship may record my appearance also.
Mr. N.C. Panigrahi, learned senior counsel, appearing for the
Opposite party state vigilance.
being special counsel, has opposed the prayer of the petitioner. Yes.
16.
Yes. Hmm?
16.
Yeah, sorry.
17.
Where are they?
There on the can not.
12 o'clock. 12 o'clock. Yes.
19.
Yes.
Sorry?
Sorry?
46, 49, Mediation Petitioner is the owner of the unity matter, director of the company. So he has deducted the employee share, EPF share money. He has also not deposited the employer share. That is almost 30 lakhs on. This is this period of 2012 and 13 man. Subsequent to 2015, I have deposited the petitioner deposited the entire amount. In the meantime, 2022, that
Are you facing any prosecution by PF department?
No, my lord. EPF department, they have filed this.
This one.
This one.
Okay.
In the middle, that NCL has taken over.
So that is a subsequent thing.
Subsequently, 2022.
Yes.
That my subsequent requirement, I have paid entire dues monthly. Due to my fixation in the market matter,
The moratorium, IB proceeding moratorium will not help you.
due to this presently, my lord, the NBW has been issued.
NBW, I'll pass and go and appear. Where is NBW?
That NBW has not annexed, that record is not traceable. That lordship has the page 18, that has been reflected. NBW has been issued.
You won't appear. I'll just record that. I'll keep the execution of NBW. Item
19.
Okay. Execution of NBW
Till their appearance.
till you appear. 18, huh? Page 18.
19.
No, 18. Page 18 is showing. Where is that? Where is that?
Charge sheet showing absconder.
The
Okay.
third paragraph, the last 4 lines.
Petitioner,
During course of our investigation, NBW obtained by the IO.
petitioner is an accused in FIR number so. During investigation, a charge sheet has been filed showing the petitioner is an absconder. Therefore, the court of which court? JMFC? Huh?
JMFC rural, Patan.
JMC also had issued NBW against the NBW against the petitioner on NBW against the petitioner. Let the counsel for the petitioner submits that you would appear before the competent appear before the court below on or before 30th of May, 30th May, and seek remedy available to him under law. Taking into consideration the statement made at the bar, the NBW issued against the petitioner, the operation of shall not be executed till 30th May, so subject to 30th May 2024, subject to petitioner appearing before the court and availing the remedy as per law. Disposal. Yes.
Item 20.
Yes. Cognizance order.
Yeah.
What is the offense?
Offense is 296. The allegation is, I entered into my father's, this is father's room,
Huh.
in my house, and tried to sit. For that purpose, such a FIR has been filed and
Who has filed the FIR?
another person claiming to be my brother.
Or then what to do?
He is not.
You must not be having good relationship with your father. You are staying somewhere else.
But-
You get inside your father's house and stolen property to what to do?
No, no.
It's between brothers.
I'm the inmate of the shed. I am inmate of the shed. My father expired.
Well, see,
So-
these are the issues, brothers and all.
Okay, glance to page 9 below. The affair.
Where is your brother is implicated?
Reconnath.
You implicate your brother.
So,
You implicate your brother. I'll issue notice and we'll settle here. What is this? Right on. Land Council for the petitioner submits that seeks leave to implead the informant as opposite party number 2. Let him do so. The course of the counter assignment.
Yeah.
Right now. Land Council for the petitioner says that the opposite party number 2 informant is his brother.
Yes.
Whose brother? Or 3 of you are brothers or what? Kaushik Samantray,
Yes.
Shikha Samantray,
Is the brother.
and Soren Samantray. Who are they?
Kaushik is the brother. Soren is the son of the brother.
Okay. Land Council for the petitioner submits that petition number 1 is the brother of informant, and petition number 2 and 3 are
Wife and son.
the wife and son of petitioner number 1. The perusal of the allegation made against the petitioner in the FIR and charge sheet indicates that it is basically a family dispute. Issue notice to so and so, written evidence so and so. Land Council for the petitioner submits that he would endeavor to settle the dispute out of court. As the dispute is dispute is among the family members, Written date video, and in the internagnum, the proceedings so and so state.
Okay.
You bring him so that we can settle it.
Yeah.
Okay.
21.
May I please your lordship? May I please your lordship?
Yes.
This CRLMC is filed, your lordship, against the impugned order passed by the law section the Sambalpur, white revision case number 7 by 223.
What is this?
This is
Yes.
a case under section 138 of NI Act, my lord.
Who are you?
Sir, I am the complainant in this case.
Complainant. Okay.
Complainant. The gist of the case is that, my lord, that before the trial court, the accused, after the closure of defense evidence, filed a petition, praying therein to send the content and amount of the check to a handwriting expert in contravention of section 20 of the NI Act. So also a recent decision of the Honorable Apex Court.
No, the revisional court has set aside the what you call the conviction order.
Revisional court, no conviction order, my lord. This is the interlocutory order. It was entertained by the session judge to send to the handwriting expert of the content and amount of the checks, which is totally in contravention of section 20 of the NI Act, Your Honor. So also a recent decision of the Apex Court.
Let me issue notice. Issue notice to the opposite party number. कितने number थिला?
21.
21 था ना?
I भी अच्छे, my lord, to stay the proceeding of the lower trial court.
You are the complainant. Why do you want to stay it? Stay the impugn order.
Lower court will pressure me to argue in this matter. Unless until it is stayed, I will be prejudiced, my lord.
Okay. Issue notice to the opposite party, retainable within such time. And in the meantime, the operation of the impugn order dated 6/12/2023 passed by the Lieutenant Sessions Judge Sambalpur in criminal revision number 7 of 2023 is stayed. Okay, next.
23.
Yes.
It's the accused person acquitted in the meantime, and page 7, and it should 12 my lord. Three persons have been acquitted in the meantime.
How many accused persons? Total?
6 accused.
3 were acquitted. And you are 3 now.
Yes.
You are
Before
3.
your lordship.
You were absconding.
Not absconding, they are on bail.
My lord, those
And
who have acquitted, my lord,
Huh?
they are the CCL, my lord.
Huh? There?
CCL, my lord.
Yes.
And
There
they,
is the
they
CCL.
have, the case has been acquitted before Juvenile Justice Board, my lord. And that case and the witnesses for the other accused is different, my lord. So it is not
They
appropriate
are not supported,
to-
so far as they are on the same footing, my lord. So far as the petition number,
no,
allegation
same putting is
against
the
the
result.
allegation against my lord, petition number 3 was assaulted by means of a weapon, my lord. And they have not stated anything.
Show me one paragraph where you get.
Your lordship, kindly see. Page 14, my lord, para 9. On scrutiny of the prosecution evidence, it is asserted that the informant PW6 and his wife PW7 are post-occurrence witness. And
No,
they
come,
have
no,
not
no, no.
seen.
Come to page 12. Page 12. Para 6. Read it. PW6.
PW6,
The informant.
the informant has stated in his evidence that the incident took place
In
in the year
2013.
2015.
On
And
the date of
alleged
alleged
incident,
son had gone to the market to purchase the
some
mushroom, and he
He
heard that
that.
someone assaulted his son.
Yes, ma'am.
So
he
he rushed
rushed
to the spot and found his son
was
lying on the ground
and bleeding.
bleeding.
It is further stated by PW6 that
On being
on
asked,
being
his
asked,
son
his
told
son
that.
told that one
Bhalu Samar.
assaulted him after some
Who is
time.
Bhalu Samar?
Petition number 3. Petition number 3.
After some time, the police so then
Thereafter lost the affair.
okay, PW, the victim injured. In the
Victim
case
injured by
stated that
PW
evidence
I-
also that he was returning from so to market.
Giri
One
Market,
Bhalu Samar called him
called him.
and abused him in obscene language. And thereafter,
JCL
JCL along with their associates got hold of him and Bhalu Samar assaulted him. So these are the evidences
Yes,
which has come on record.
yes.
Yes.
So how would you say that you get the benefit of this? This has to be this has to be seen as per the evidences adduced so far those accused persons are.
Yes,
there.
ma'am.
Now you can't get the benefit of it.
So far as the allegation is concerned, as per PW6, my lord, injured, my lord. Allegation against petition number 3. So far as the 1 and 2 is concerned, there is no allegation.
I don't know what the complicity is there. What kind of evidence will come on record?
That is there in the, he has stated the juveniles are controlled and hallucinal assaulted. That is the evidence.
Para 8
For
also,
me-
PW7 also says, PW5 says,
The
PW6 says.
No, he has not stated so far 1 and 2 is concerned by.
I am not here to analyze or
Yeah.
appreciate the evidence.
There is allegation against petition.
All the witnesses in the trial also implicated.
I'll supply all the evidence copy.
What supply? These are there.
This is the only so far as
What best I can do is I can expedite the trial.
Yes, ma'am.
PW petition number 3 allegation is there. I am not pressing my lord.
No. I can't.
Well,
I'll
so far
just
as the
expedite because the incident happened some
2013, my lord.
FIR was filed on.
2013, my lord.
FIR was filed on.
Only Cognizance taken, my lord, against the petitioner.
2013, my lord, FIR was lost.
The petition.
That is 22/10/2013.
The
Your
petition.
lordship considered 1 and 2 is concerned. 3, your lordship.
No. Petitioners have challenged the entire criminal prosecution initiated against them on the ground that the other 3 accused persons, namely CCLs,
Yes,
have faced the trial, and the Juvenile Justice Board has the Principal Magistrate Juvenile Justice Board, Barampur, Ganja, in JR case number 110 of 2013. Its order dated 8/7/2022 have acquitted all the 3 accused persons. On the basis of the said judgment, the petitioners seeks vestment of the entire proceeding initiated against them. perusal of the judgment passed by the Juvenile Justice Board indicates that there are the evidences so recorded by the prosecution vis-a-vis the accused, those who have faced the trial, and the evidence of PW 5, 6, and 7. 7. The witnesses, namely 5, 6, and 7, is implicated one of the petitioners in the present case. Therefore, I'm not inclined to interfere in the present case. However, taking into consideration the fact that the incident had taken place in 2013 and charge sheet was filed in 2014. And the trial is prolonging since then. I am of the considered view that the trial court should do well to complete to complete the trial as expeditiously as possible, preferably within 6 months hence. Yes.
Yes, my lord.
Liberty.
Your lordship, liberty may be granted, I will approach the sessions court.
And
showing this, my
the
lord.
petitioner also.
That target, your lordship may.
Target is best, I tell you.
Target,
Cognizance.
the lordship direct.
I have given that
liberty
liberty.
may be granted,
That
I
li-
will
that
showing
liberty-
this, my lord.
That liberty is also I have given. The
Correct.
petitioner,
Target, I
petitioner is also granted liberty to raise this issue before the court
Settle
below, before the trial court, raising all these points.
Sorry for the interference, my lord.
Target problem kona. People are
target.
6 months cut degi as expedition for.
For the interference,
Sorry for the
interference,
Disposal.
my lord.
24.
Yes.
My lord. May it please your lordship. My lord, I am in VC, your lordship.
Yes.
My lord. The petitioner, my lord, is a woman, your lordship. She is working as a nurse. There are 4 accused persons. I have not approached your lordship for any other accused persons other than this petitioner. Only one petitioner is there, your lordship. Now the petitioner has been implicated, which is purely a civil dispute, and there are civil matters pending between both the parties. Your lordship may kindly see
What are the allegations? Let us see what are the allegations.
my lord, the allegation is under section, your lordship, 341, 452, 323.
You are
350
Puspa Manjari.
Pushpa Manjari Raut.
Raut.
The only
Yes.
petitioner. There are 4 accused persons. I have not filed any petition for other 3 accused persons.
This is the first installment. Once notice is issued, the other 3 will come.
I undertake, my lord, I will not file because
Why
I am
should you
ready to.
undertake? They are not your client. How can you take undertaking from them?
She has come along with her husband. Her husband is an accused here.
No. How can you give undertaking those who are not your clients also?
I have kept wakalatnama for her husband, but I didn't file. I said that this is a matter you defend. They are ready to defend, your lordship. Your lordship may kindly say, because my lord, I am a nurse. I am working in the government hospital. Now I have been rewarded for my good work. That is the reason, your lordship, I have been targeted.
Yes.
Your lordship may kindly see, on 30th of July 2022, only one fact I am bringing to your lordship's knowledge. On
Right.
30th of July 2022, the informant says, I have assaulted her. Your lordship may kindly see Annexure 7, page 45.
45.
Annexure 7, page 45.
Okay. Yes.
This is the information I have obtained from the government hospital itself where I am working.
With
On
reference
serial number 7 is Pushpa Manjari Raut. I was on duty from 9:15 to 8:30 am. And on 3,
right.
yes, your lordship. Your lordship may kindly see the reason why they have implicated me. Your lordship may kindly see, I have stated in paragraph 11, page 9.
Page 9.
My
But
lord.
incident was occurred in the 8:30 morning.
8:30 I was on duty.
No.
It can be
8:30
done.
am.
Yes, your lordship.
8:30 your duty is over.
Duty is over, your lordship. So it is not possible for me to come from the hospital immediately and go assault someone.
These are the things you.
Factual disputes. Your lordship may kindly see. I do believe. But my lord may kindly see. That is page.
Except the plea of alibi, what do you have?
My lord, page 32. Page 32. it is a civil dispute since 2018. This FIR has been lodged in 2020. Now your lordship may not dispute this fact, at least that this purely civil dispute.
Why should I dispute? The prosecutor will dispute.
Must
I'm not
be,
disputing anything.
my lord, that must not be given criminal color. And your lordship, the harassment I am suffering, I have submitted in paragraph 11. This annexure 5 is the civil dispute between both the families.
What is this? What is this?
This is a civil suit filed before the Learned Civil Judge Junior Division Puri. It is since 2018, the matter is pending.
Allegations are assault and all.
Allegations are assault because of this civil dispute only.
See, this is always a double-edged weapon, you know. You have enmity because of the civil dispute. This might have happened also.
My lord, with respect to this woman, it is alleged that I have assaulted, abused the husband of the informant, who happens to be a person 10-15 years older than me. From the prosecution evidence, from the materials adduced by prosecution, if it is even a believable story against me, your lordship, I have nothing to say. But your lordship may kindly consider page 11, paragraph 11 of my paragraph CRLMC petition. I have stated, your lordship, paragraph 11.
Paragraph 11.
Yes, your lordship.
Yes.
My lord may consider that
Yes.
I am reading, my lord. That it is pertinent to mention here that the petitioner is so well in her job and serving the people with utmost sincerity, for which the government of Odisha has sent the petitioner to Ceylon for a training. The petitioner had attended this training program at Sri Lanka, and now the state government has proposed the name of the petitioner for a training program in Dubai, and for which the police verification should be done. Due to pendency of the said criminal case, it will be difficult for the petitioner to avail this opportunity. The only reason, my lord, to implicate me, to debar, I am a nurse, my lord. In all India level, 25 nurses were selected. This is my lord, this is going to entirely ruin my career. That is the reason I am before your lordship, and I have stated, I
understand the predicament you are facing, but the problem is how to get out of the allegations which are made against you. The offences are 341, 452, 323 and all.
And in which
So how will you get out of it?
The reason is also that the reason, my lord,
And
only
there
that
is a suit which is pending. This is again I am telling you, it's a double-edged weapon. Because of the civil dispute between the two families, this incident might have happened, and you are taking a plea by alibi, saying that you are working till.
This is only an additional piece of
evidence.
evidence.
Also that it may be 10 minutes here there. How do I know?
This is only an additional piece of evidence brought before your lordship to bring your lordship's knowledge that this is prima facie appears to be false implication, but I do.
Are you on bail?
My lord, under 41A, police has issued notice to us and released on bail.
I will see the best relief. What I can give you is you can be exempted from personal appearance in view of the fact that you are a working nurse. And 205, you move application.
Your lordship may kindly consider to issue notice if they appear. The matter may, with respect to petitioner, may be decided.
Let us see. He is a very okay. Issue notice.
Yes.
And your lordship, may I pray with respect to with respect to IA lordship, with respect to
issue notice on IA.
With respect to
and I am giving a very short date so that let them come. We'll sort it out. Okay, so give us a short date because her career may be
7th May.
7th May, so that we will sort it out. Let them come.
Only your lordship may permit that in between I can seek one adjournment if the case is posted.
In between, Mr. Mishra and counsel for the petitioner submit that he would be moving application before the trial court for an adjournment. If such application is moved, the same application.
My lord, oblige, my lord.
It's 50, na?
53, my lord.
53. Okay.
This is a short application for a small modification. My lords may kindly have a look at the last order.
Yes.
22nd of March, my lord.
Yes. It's a typo.
Yes, no, yes, my lord. Well, what I had prayed was that due to kindly see my application today.
Now, which part is required to be?
My lord, the last part, my lord, I had requested your lordships that because the IGP, who is the IO, is conducting several other assignments.
Yes.
The SP will investigate and the IG will
be the
So I didn't, I understand, that time I understand.
correct.
But if I alter that, it
Yeah.
amounting to altering the main order.
362 is bar.
I can't do it in contempt jurisdiction. That's
I'm
the
fi-
reason I didn't do it.
I'm
I
filing
will-
objection.
I recorded your statement so that.
Bow down, my lord, bow
I
down.
will file a regular application.
That's a better idea too.
I will file.
My lord,
Yeah, this, I'm filing a regular application. What is your problem?
Because
lordship may
in a
say-
contempt jurisdiction, I
No,
can't.
your lordship may say, my lords,
Yes.
that I'm not pressing this application and I will file an appropriate application.
That's better.
Grateful.
that's why, my lord, I have received the IA with objection. I am ready with the objection affidavit, my lord.
You raise the objection. See, you are interested in the investigation,
My lord.
whether X judge or Y judge. SP is also not a small.
No, my lord, I have not that. I am only bringing your lordship's notice about the CRPC 362, my lord. I have nothing to say.
So let the SP do it. How does it make difference? You are only interested in investigation.
Correct.
Let it be done. Why are you creating hurdles? Either X should do or Y should do.
I am not there, my lord.
The order was somebody higher in the rank of DSP. Anyway, my lord, I'll file an application. your
Because
lordship.
see, I can't do it in a contempt jurisdiction in any case.
That was my objection, my lord.
That's
What my lord
Right.
pleases to observe.
The learned Ashok Parija, Mr. Ashok Parija, learned Advocate General seeks to withdraw the present petition to present the same, to file the same.
to file an appropriate application.
To file an appropriate application
in CRLMC 1462 of 23.
CRLMC 14
62 of 2020.
1462 of 2020. With this
Grateful.
liberty-
Grateful.
with this liberty petition, application is
Grateful. Grateful.
Yes.
25.
My lord, page 30 cognizance order taken by
Yes.
page 30, my lord, challenging cognizance order, my lord.
Yes.
Taken under section 138 of NI Act.
Who are you?
And I am the accused person before the court below.
What is wrong in cognizance?
My lord, it is taken after the complaint was filed after 3 months, my lord.
Delay is already.
No, my lord, there is no delay petition has been filed.
You have, what about your check? Have you,
Check intimation was made after 3 months the complaint was filed.
what was the check amount?
70,000, 70.
Settle, pay the money and settle. Why are you will not succeed. Court has the power to condone the delay.
My lord, delay petition was not filed.
But in oral prayer, who knows?
There is no such averment like oral prayer.
Will you deposit the amount?
No, my lord.
So bluntly, you are saying no, what to do. 143 also you deposited, some 20% you deposit, I'll issue notice. Otherwise, I am not interfering. In 138 matters, see, these are the matters,
Your lordship may issue notice, I will deposit here, my lord, if he comes and appear before the sun.
only on the ground that you will be settling.
Yes, my lord, I will settle, try to best level to settle the matter.
That is the dispute. 70,000 rupees, you pay some installment or something. You finish that.
My lord.
Unless the petitioner is challenging the order dated so and so taking cognizance. Order dated 22/1/2024 passed by which court?
JMFC Binika.
GMC so and so in ICC case number 7 of 2023, whereby the cognizance of the offence under section 138 NI has been taken against the petitioner. Taken into it. Then consequently, the petitioner submits that the complaint was filed belatedly, however, without there being an application, the trial court has taken cognizance. Cognizance by condoning the delay of 3 months. Condoning the 3 months. He further submits that he would make all endeavor to settle the dispute. Therefore, he seeks indulgence of this court. Issue notice to the opposite party, returnable.
Miscase, my lord.
Issue notice on miscase also. Yes.
26.
May I please, Your Lordship? I am appearing through virtual mode. Your Lordship,
Yes.
I seek an adjournment, sought adjournment, Your Lordship.
Adjournment.
Any kindly be fixed.
Adjournment. Yes. Next.
27.
May I please? Back to my lord. On that date, my lord, I am very much sorry.
Which one?
My lord, that item 27. that-
what had happened?
My lord, 11 accused are there. And out of 11, 8 my lord faced trial. Subsequently, they were acquitted. And my lord, 3 remained. And that order sheet itself indicates, my lord, which I have handed.
So what do you want? I forgot everything. What you
My
said.
lord, I want, my lord, that they have faced trial and subsequently they were acquitted and nobody supported the prosecution case. And my lord, your lordship was.
You were absconding.
My lord.
Okay.
These two
You are
persons are-
absconding. Where is the judgment?
My lord, I have handed over the lordship's order. And also the judgment, my lord.
The same order you want?
Yes, my lord. That last portion, my lord, 2 days, I pray before your lordship that in the same.
Okay. Oh, what is the substantive order? The legal will submit that you report below. You would move application for grants to bail the application was maybe contact for a report. Report on the phone that they is possibly issue the
All these petitioners were absconded, my lord.
Absconded. 2 day, 1 day, same day, same. The charge sheet was filed against them, showing
Yes,
them
ma'am.
absconder.
My lord.
Absconder.
Yes, ma'am. And the offences are grievous, my lord.
Right.
Tender bits
No
and
problem. FIR PS case number so and so against so and so was registered against the petitioner and against 11 accused persons. 11 accused persons. Okay. 11 accused persons. Out of the 11 accused persons, 8 of them were apprehended and faced the trial. While order dated by judgment dated 12/1/2022, the learned Assistant Sessions Judge Patamundai in ST case number 68 of 2020 had recorded the acquittal against all the 8 accused persons. On the strength of the said judgment, the petitioners seek indulgence of this court, indulgence of this court. Also, the next problem, the petitioners, the present 3 petitioners, 2 petitioners, 3 present petitioners, 2 petitioners. The present 2 petitioners were shown as an absconder in the charge sheet. Absconder in the charge sheet. Therefore, NBW has been issued against them. Issued against them. I have perused the document on record and evaluated the judgment. It record the one. Mr. Saul Jagre, not important. Okay. January 22. You do it 1 day. Same day, same day. Same day.
Okay. Records shall be transmitted in the court of the appeal.
Records.
Because the case is pending before the JMFC from NGN Rajanagar. The second hour that the petitioner moved bail application before the higher room, that is the applicant Petitioner Patamundai. So on the same day, records shall be transmitted.
The records are there here.
My record is
the record pertaining to the ST case number 58 of 2000.
No, record of the GR case number.
GR case number?
GR case number, my lord.
GR case number 162 of 2018. 2018 shall be transmitted to the trial court.
Yes.
trial.
At the cost of the petitioner.
At the cost of petitioner. At the cost of petitioner.
So the assistance are from the Procedural.
I just come.
Public.
I just come. Prosecution is not agreed.
Is praying for to add the 376 to N. No.
That is 427.
427, 436,
Sorry,
307. Where is your application? 311?
Application.
Here.
Annex 3, page 21.
Who is this witness?
There is the investigation also.
IO.
And the law and court below held that the exhibit 26 is not the fire rating.
161, but whether the IO had produced to the court to be recorded the statement of so. This
There is no question.
Where is the impugn order from?
Page 27.
What does it say?
It says that there is no clarification or any ambiguity of the prosecution. Secondly, it is the exhibit 26 is not the fire report.
Already, anyway, we have to issue notice to the accused persons. Where are the accused persons? The accused persons are Baidyanath Sahu. Issue notice to opposite party number 2 and 3. 1 and 2. Written evidence and say Mr. Rahul APS for the state and issue notice for opposite party number 3.
The proceeding, the accused statement will be going on 16.
Let counsel the petition submit that before the trial court, the matter is scheduled for recording of statement of the accused under section 130, 313 CRPC. We praise that we praise the liberty to move application before the court below for seeking the adjournment. If such application is moved, the same satisfaction. You move application. Okay.
29 is the identical matter, the same one.
Which one?
29.
29 also the
same.
Yes.
Yes. 30.
30.
Yes. Sorry? Yes. 24. Okay. Yes.
Alleged offense under section 506.
What is wrong in it? What is wrong in it?
It shall not refer your perceived juvenile, and the matter has already 506. Actually, all the offences are not made out against the present fiction. So far as the allegation that the 9 allegation against the informant, present opposite party, number 2, 376 allegations. Therefore, to counter blast against my family members as well as
Counter blast or not, see, I can't say at this stage. I have to only see the final. I have to only see the charge sheet. Whether any case is prima facie made out or not, that has to be seen at the time of cognizance. See the charge sheet. Come to charge sheet at page 22.
22.
Page 20. Read
second paragraph. visited this spot.
Visited this spot, being identified the complainant, the spot is in near a new bus stand. Road Barampur, located in distance about 2 kilometers towards west, whether we have to examine the complainant as well as the other witnesses recorded their statement. As the punishment of the offence in this case is below 7 years, requested the accused persons namely Sibo Sankar Mishra, late Sibo Sankar Mishra.
No, first paragraph read. While the complainant was standing in front of her house.
Your Lordship, the three active named charged person have already approached before Your Lordship. Your Lordship also granted stay and stayed the proceeding in another.
Where is that?
Yes, copy also, order also attached to the.
Where is that?
Page, get the page.
Where is that?
Attached to the brief.
Where is that order?
CRLMC 3031.
Where is that?
Attached to the brief.
Item 30, na? 30.
Yes, item 30.
No, there is nothing attached.
Yes, Your Lordship.
Annexure kete ko unadi.
He has not filed anything. He has not filed anything, nothing is there.
Yes, Your Lordship. The defect remove hoई परिबने हम से previous order टा न दे. Again, दिया है. Then no पाखरे नहीं available कुंदो brief रे attached है. Therefore, number है.
Criminal. This one.
3031.
3031, yes.
Of 26.
Yes, where are uncounted for this is regarding, this is insofar as Indira Sahu and Sri Ramchandra Sahu is
Sri
concerned.
Ramchandra Sahu, Indira Sahu, and another 3.
And what about you? Who are you?
I am the
Dr. Ipsita Sahu.
Ipsita Sahu, the Juvenile, Your Lordship. Minor.
You have challenged the cognizance. They have also challenged the cognizance order.
Cognizance.
Cognizance order dated, causing the order date 31/3/2023. Where is the cognizance order in your case? 31/3.
नहीं हमारा वाला 23 27
How there are two different, how there can be two different.
Because petitioner before Your Lordship is Juvenile.
Okay. The co-accused, namely Indira Sahu and Sriram Sahu, had also assailed the cognizance order dated 31/3/2023, passed by SDJM Barampur in GR case number 2993 of 2022. Before this court by filing CRLMC number 3031 of 2023. While order dated 24/7/2023, this court had issued notice to the opposite parties and stayed the proceeding in GR case number 2993 and stayed the proceeding. The present petitioners are the how many of you are? Present petitioner is a juvenile. Insofar as the merit of the case is concerned, her case is similar to that of the co-accused persons. So therefore, she has filed the present petition seeking passing up the cognizance order. Issue notice to the opposite party, returnable so and so, opposite party number returnable so and so. Tag the matter along with the CRLMC number 3031 so and so. In the meanwhile, the proceeding before so and so is taken. Proceeding before, you tell me the day. Where which is
proceeding before the learned principal magistrate, JJ Board, Ganjam.
Proceeding before learned principal magistrate JJ Board Ganjam, Barampur in which case? In GR case number 17 of 2023 is stayed till next date of it. Yes.
31 compromise.
31 compromise. 31. Settlement? Yes. What are the offenses?
Copy not served.
Copy already served, my lord.
Parties are there.
My lord.
What is the allegation?
Offense under section 294, 223,
Tell the
340.
allegation, fact, sections, why I am telling section. What are the allegations?
Well, the allegation is that on that consent date, there was a scuffle between the present petitioner and the informant's son, my lord. And matter has been settled, my lord.
Yes, Mr. Maharaj.
Well, I don't have copy.
Give a copy at least.
Copy may be given.
Copy state has been filed. I've served a copy of the state, my lord.
Don't get into dispute now, give it.
What a copy they did.
Give it.
31.
Yes.
Yes.
Just take it up.
Kobila Prasad Mahanti. Rispi joint. Rispi joint.
Who is Kobila Prasad Mahanti? He is the victim. Victim. His father was the informant.
Yes, my lord.
Where is his father?
Father
Yes, sir, Mahanti.
died.
You'll also make that indicated.
Dispute. Right. Right. Petitioners are accused in FIR number. So under section so. So the petitioner.
No.
The
Your lordship, affidavit has not been filed. Let them to file the affidavit, let it pass over.
File an affidavit.
Affidavit reason to.
As your lordship pleases, my lord.
I'm recording it.
Okay.
File it, then I'll take it up at 2 o'clock, but I'm recording it.
Yes.
Yes, lord.
Yes. Subject to filing. Right now. So the late father of opposite party number 2 registered the FIR against the petitioner. It is alleged alleged by the late father of the opposite party number 2 that on 10/11/2023 while the informant along with his son opposite party number 2 traveling in his car near the Chaudhary Bazaar, the petitioner stopped their car and assaulted the son of assaulted them and torn the sword. Upon protest, the petitioners abused in obscene languages and threatened them with dire consequences. Dire consequences. Accordingly, the FIR was registered. FIR PS case number 290 of 2023 was registered against the petitioner. After investigation, the charge sheet in the present case was filed on 11/12/2023. When the matter stood thus, the parties have entered into the settlement. The accused persons and the opposite party number 2 are present in the court. The informant in the present case has already, who was the father of opposite party number 2, has expired. The parties who are present in the court are represented by their respective counsel and identified by them. They have also filed their self-attested copies of Aadhaar card to establish their identity, which are taken. The petitioner and opposite party number 2 have filed a joint affidavit dated as joint affidavit dated also inter alia stating as under. In one paragraph, you write.
Yes, madam.
As under. Okay. Mr. Maharaja appears for the state and submits that since the informant has already expired and the parties have settled their dispute and filed an affidavit before this court. Affidavit with this court. There is a court. This court can give indulgence to them at this
All
stage.
the offences are compoundable
At
except
this stage, particularly because all the offences alleged against the petitioners are compoundable except
294 of course.
except an offence under section 294 IPC, just 294 IPC. Taking into consideration the settled position of law pronounced by the Honorable Supreme Court in Gyansing, so and so, so and so, I am of the considered view that subjecting the petitioners to trial would be a futile exercise. Therefore, the petition deserves merit. Petition deserves merit. Hence, accordingly, the FIR number so and so and the consequential proceeding arising thereof, of course.
Grateful, my lord.
Please file, give the
Immediately,
affidavit, because one paragraph of that.
Yes, ma'am.
affidavit-
Yes, immediately.
Yes. And one more matter was there, settlement, two more.
17.
17, 17?
17.
Yes.
I am appearing for the opposite party.
Yes. Affidavit, I tell you one thing.
33.
Otherwise, I'll impose cost now. See the kind of affidavit, what is this? You have to at least write something.
32 টাকা ভাই
2 o'clock he will come. Yes.
33.
Urgent. Take out your mask. Urgent. Okay.
34.
34
Yes. The case has been initiated before the OEC Orissa State Commission for Protection of Child Rights by the opposite party number 2. At their period, she has made allegation that she was in love when she was reading at class 5-1 with one Korumachi, and she became pregnant. And subsequently, she gave a complaint before the collector, and due to the interference of the collector, she was taken to the CWC, where she was delivered a girl child. And subsequently, that girl child was put to adoption on the basis of a order passed by the London district judge. Adhering all the provisions related to the Juvenile Justice Act. After 2 years, she made a complaint before the OCPCR during her stay at CWC, how she has been harassed and how her child was sold by the LPO, the present petitioner, and others. The chairman OCPCR gave a direction to the chairman CWC to make an inquiry and a report. Instead of giving report to the OCPCR, the chairman CWC made a complaint before the Marsagi police station on the basis of which a case was registered by annexure 1. Under section 370, 417, 294, 506, 34, the sections of the SC/ST Act. Thereafter, OSCPCR disposed of the case. You are challenging what?
I am challenging the order passed by the London magistrate,
Taking cognizance.
Judge by annexure 16,
Taking cognizance.
No discharge.
No, not discharge, It is a petition filed by your lordship, prior to that order, I will show your lordship that the order.
What is this order? Tell me first.
This order, in one order, the London trial court stated that directed the investigating officer to file final format. By order dated by the annexure 14, your lordship kindly see the page 67. 67,
Yes. Operating part?
Operating part, the last line your lordship can see put up on 11/7/2022 for final format. Because while the
67.
Page 67.
Okay.
While the petitioner was in custody, during that time, preliminary charge was filed. Charge I have annexed, keeping the investigation open. That is when the case was posted for charge. The petitioner filed a petition that since the documents which are seized by the IO during investigation, particularly the CMA number 18 of 2018, the order passed by the London district judge, that has also been not produced before the court.
All these, there are so complicated facts, overlapping
I have
facts.
annexed everything.
No, that's right. That is the reason the police has to look into all these things.
Now, police has not filed all the papers. Police has seized all the papers. All the papers are with the police.
The court has only said that file the final form.
Final. When at this stage, police has not filed the final form. Again, the case has posted for charge. I filed a petition, since because earlier order dated, it has not been complied with. The London judge proceeded.
And frame the charge.
No, the charge has not been filed. That petition has been rejected. That is the impugned here.
Yes, Mr. Maharaj.
May Lordship, may kindly see page 74.
74.
If it is right, my lord, don't find 74.
Yes, I'm there.
Now, in the middle portion, 173 clause 8 of CRPC
Yes.
written, just thereafter.
Regardless the result of the
Yes.
investigation of 173.
Yes, that happened, 4 lines
repeated.
thereafter.
Hmm.
Especially when it has already been taken cognizance of the offences and procedure with the case against the accused person, including the petitioner. Then will also come to the so far as the petition, second para. Second para. This so far the petition seeking discharge of the accused person is concerned, it is noted by the order dated 18/7/2023. This court has rejected a similar prayer on merit, and this court does not have no power to alter its order, even on the basis of the fresh materials produced before it. More so, the instant publication is the third attempt by the accused person seeking their discharge from the allegation leveled against them by the prosecution. It is significant to note that as per the order of the Honorable Court, the second application was entertained and considered by the order dated 18/7/2023. In the next page, you'll also see. By the order dated 21/9/2020, this court on the application of the accused persons had asked the IO to submit the documents seized by him since the date of the submission of preliminary charge sheet in course of the investigation. He is undertaking in terms of section 173 clause 8 of the CRPC. Accordingly, the IO has produced those documents of which the order passed by the district judge Kendrapara in CMA number so and so is claimed by the accused person to be the significant document. Then you'll also may kindly turn to learned counsel, third para. Learned counsel for the state has countered the submission contending that the order passed in CMC number 80 has nothing to do with the allegation of trafficking and other offences as labeled in the charge sheet. In as much as the deed of surrender, this is important. The deed of surrender based on which the order in CMA 23/2018 was passed is a false document, snatched from the victim on false pretext. So it is to be tested in the trial. It cannot be.
I am sorry, sir. That is the I have annexed the document. A lot of for a moment, kindly come to annex. But that is what the police say that is I have given the background of the case. Initially, this case was instituted on the basis of a direction given by the OSCPC to the chairman CWC to inquire into the matter. Now the chairman OSCPC on the basis of the inquiry report had disposed of the case matter. For a moment, I want to draw your lordship's kind attention to the relevant portion of that order, where the CMA number and deed of surrender and everything. The deed of surrender means deed of surrender of that child under the Juvenile Justice Act. Adoption under the Juvenile Justice Act. All the procedure part under the Juvenile. Last mirror, when a child is put to adoption, an order of the London district judge required, which was filed by the CWC before the London district judge. And according to the London district judge passed an order, which was CMA number 18 of 2002-22. So far as the allegation of the CWC chairman the affair, which was lodged before the Marsagi, what is the intention, what is the conduct of the informant CWC chairman, the OSCPC. Who are you? Who are you, by the way?
I am the LPO, legal probation officer, under the Juvenile Justice Act. I am giving the relevant portion, only one para I am drawing your lordship kind attention. Lordship kindly come to
Malik is the mother of the
girl child. That during that time, she was 12 years old when she delivered the child. That is why she didn't take the child. Everything in procedure that has been written.
The girl child is with whom now?
She had been adopted
by adopted parent.
Adopted by the adopted parent by virtue of the order passed by the London district.
When she was adopted?
She was adopted in the 2017.
That adoption itself is illegal because the mother was impressed.
I am only worried about the child,
yes,
who has already been adopted since 2017.
Mother was impressed upon
adopted parents now because of this litigation. She may be displaced.
The mother was impressed upon that the child is going to for treatment.
She would be displaced ultimately.
But for a moment, your lordship kindly see the order.
I just issue notice, let us.
Yes.
Let us issue notice to.
The chairman OSCPC has written everything. How for his ulterior motive, the CWC chairman has given a wrong report to the police.
When will the
All these things has to
whether
be
it is
tested
a
in the
wrong
trial
or
and
right
handle.
problem.
No, I am taking it to place the trial. Mail.
What do you want?
I am not appealing to place the trial.
What do you want?
My lord, till date, my lord, final form has not been filed.
When
On
are
the
you going to
basis
file
of the
file?
preliminary
As per the earlier order,
charge will be
when are you going to file 173(8) report now?
In the meantime, कौन है तुम जानेंगे?
No, I am submitting my lord. Your lordship can limit that. My lord, record my submission. I don't
if
dispute. That is my.
if they file it, then you are satisfied.
My lord, I am satisfied. If they file the final form, my lord, I am satisfied.
Preliminary charge sheet already filed.
Tomorrow.
No, on the basis of the preliminary charge sheet, you can
Let it be tomorrow.
No, charge. Why? Your lordship. A preliminary charge sheet has already been filed against the
No,
petitioner.
I am not on that. What,
when the lord and
one minute.
passed that order.
1 minute. There is an order of decisions that you
final
have to
form.
173(8) report you have to file. The secondary charge.
Kept open. Yes.
He says that once that order is complied, he is satisfied.
Lord and district also
I just want to know why it was not filed or whether it is filed or not.
Yes. I will take it
Tomorrow. Tomorrow you just ask.
Lord and district directed the IA to file the final form.
It has to be complied.
Yes, ma'am. Well, without compliance, we will hide the Lord and
Either it might have been filed by now, or you seek instruction how much time they will
It
take.
will take,
We'll
yes.
record it and
Yes,
dispose
yes.
it out tomorrow.
That is the only.
Tomorrow.
35.
Sorry.
Yes.
On behalf of Sumarindar, may I place my order?
Yes.
The offense under section 498(306), my wife committed suicide after.
Stated against the Samar Kumar Mishra, not the petitioner. For that, the lordship will come to the charge sheet, page number 26.
No. What is this here? Basically you are Mr. Vijay Lakshmi.
My lord.
Yes.
My lord, page number 26.
Here, my lord, the application has been filed by suppressing one application on the same ground. This application is rejected.
No. Let me submit first. I have read the certificate. That order is with the file. First, let me submit.
No, where is that order?
Yes, my lord, that order. I would do that application. All things are discussed with the land and court below. When such thing is fine, then my lord, I file this application. Without, yes, I am. Let me submit first.
सब सबमिट कर देंगे लॉर्डशिप में सर्टिफिकेट पोर्शन रे देखिले ए पिटिशन रो सर्टिफिकेट पोर्शन देखंतु
It is
the matter out of which CRM arises never before the channel court never before तो फिर कोड कौन मेंशन करले अपन सर्टिफिकेट देछन एफिडेविट करके अपन नेवर बिफोर CLMC 704/2024 704
you have written, not he has not written.
कौन निजे लिखछन सेटा मु कहूची अपन
Read it out.
कौन लिखछन अपन देखो ना
The matter out of which this CRMC was before this honorable court, while CRMC number 704 about 2024
Where
was
are you reading?
written.
Where he is reading?
कौन लिखछन टिके देखिले आपण के
आपण को न लिखि कि देई इन कॉपी तापर लिखथिबे.
My head says copy paste भाई बारे me say the please.
Don't do that.
No, sir.
I got
No.
अच्छा you are for the opposing party or opposing.
No, let me complete first.
There are two.
Page my lord. ये जो page है दिला वाला.
Anyway, but how will you get over the order dated 14/3/2024 passed by this court in NCRLMC 704 of 2020?
Yes.
You have said, let counsel the petitioner seeks to withdraw the present petition to raise all the points before the trial court at the appropriate stage.
Yes, my
Where are
lord.
you?
Thereafter, again, my lord, fine. Everything when discussed before the court below, that it is find out that that is a mistake of the my lord prosecution, that the police is not given the charge sheet against the present petitioner. Where out the court will have taken.
All this thing before trial court, you have taken liberty to. Why are you coming again?
No. For that, my lord, I am not challenged the order. The 14 order, I am not challenged. मु 14 order को lordship से before challenge करे नहीं. That is my lord, the misconception, my friend, my lord. I have not challenged this order the 14th October 2020.
After discharge petition is rejected, he approached before your lordship, and now he is telling the cognizance order. The stage cognizance order taken first. After the judge,
you moved an application for discharge. That was rejected. That you challenged earlier
Earlier.
and you withdraw. Now you are going back and challenging it.
No, my lord.
Don't cross the limit.
No, that is not, my lord. When, my lord, the police submitted the final report against me, but the land and court below taken cognizance against the petitioner.
But
Thereafter-
thereafter charge has been framed against.
No, my lord. There are only appear. Then, my lord, simultaneously, what type of, my lord, present my brother is even appearing, and that are done in the land and court below. Thereafter, when everything was discussed, land and court below find a conclusion, then you may challenge the order of the cognizance. For that reason, my lord, I am before your lordship. I am never challenged this order. Charge is not yet been framed. Charge framed is not.
And you have never challenged the quashing of FIR also.
Well,
After
three-line
ICPC.
I am not back. My lord, when my lord, final report.
You go forward or you go backward?
My lord, final
three-line
report
policy
is submitted
case
against me
Ah,
when there is no evidence.
Case record is now posted for hearing, and till date the accused Vijay petitioner Vijay Lakshmi Das has not appeared before this court. This court has issued summons to both the accused persons, namely Samir Kumar Mishra and Vijay Lakshmi Das, by the order dated 14/10/2020. But the accused Vijay Lakshmi Das has not appeared before this court yet, and without her appearance, inadvertently, charge has been framed against only one accused, Samir Kumar Mishra.
You don't
ये
go
यदि
then.
थांते ताल चार्ज हेता दिजन
My prior
गोटे लोक रहिला तन तार एग्नेस्ट चार्ज फ्रेम
My lord, how without evidence the cognizance is taken? Prior to that, say the 3 years order. But I am challenged before lordship on the 14th October 2020.
When the
कहउछन आपण एतर चिलोजन
1 minute.
कोडिए पक्षरे
Which is that proceeding, Mr. Maharaj?
Mail.
Proceeding dated?
3/8/2020 page 28 for annexure 4.
Right down. From order dated 3/8/2023, passed by the learned JMFC 4 Cuttack in GR case number 145 of 2020. It appears that the present petitioner was not present at the time of framing of charge against the framing of charge. Therefore, the charge has been framed against the co-accused Samir Kumar Mishra. Then counsel for the petitioner, Samar Kumar Mishra. Next paragraph. In the present petitioner has challenged the cognizance order. Cognizance order dated order dated 14/10/2024. 14/10/2020, whereby the court below had taken cognizance against her cognizance for offence under section
420 of IPC.
420 of IPC. Then the counsel for the petitioner seeks
Without evidence, my lord.
to withdraw the petition to argue all these points at the before the court below at the time of framing of charges.
Charge, my lord, I will.
I have given liberty. You appear and argue.
Already.
After withdrawal of this, again also discharge petition will file. That has also been rejected. Only that he has to appear before the court, then the charge will be framed. He is not appearing and taking the plea.
You are moved application also.
Yes, that has been rejected also. And the plea is that there is a matter pending before the High Court, so therefore.
No, my brother is wrongly summoned before your lordship.
That is what is
You have sufficiently confused the trial.
I never confused. Lordship, my liberty will be given. I would raise all the point on the taking of charge, my lord. Yes, my lord.
Dispose of. Let him argue.
No, my lord, one thing. I will raise all the point on the taking of charge.
Yes.
37.
Yes.
The prima facie story reveals in the 1cc case, lordship.
What have you challenged?
I have challenged the order passed by the learned JMFC, lordship, directing the police to register case pursuant to the 1cc case. Lordship, the facts reveals from the 1cc case, lordship, kindly come to page 21. The 1cc case what was made, page 21.
Yes.
21. Accused number was, this, I am the accused number 1.
Accused number 1 was helping.
Working as manager. the accused number one was helping accused number two. This is the allegation. It is mentioned here that the accused number two had given 5,000 to my husband. This is relation between the both the partner.
You read it. What are the allegations?
Sri Santosh Kumar Naik on dated so and so, and 40,000 on dated 26/6/2000. But subsequently, my husband had again
in this clandestine manner, the accused number 1 and 2 had taken away 5 lakh rupees from the complainant by June 2020. After several complaints of the accused number 2 had given a post-dated check of so and so, Punjab so and so. But the check has already been dishonored on deposit for encashment. The complainant cheated the accused number 1 and 2 so and so. What do you want now?
The man. This is next.
These are allegations.
These are the allegations. I am only the sanctioning authority. I have sanctioned loan in favor of the.
Why have you issued the check then?
It is issued by them.
No. Clandestine manner, you are the accused number 2?
I am the accused number 1.
Anyway, just see, in the clandestine manner, accused number 1 and 2 have taken away 55 lakh rupees from the so and so. After several complaints, accused number 2 had given so and so. And the complainant cheated by the accused number 1 and 2. But after transfer of accused number 1 from the said branch, the new branch manager repeated pressurizing anyway, you have done everything and now transfer.
I have only sanctioned the loan. This agreement is between accused number 2 and this complainant, that they are the partner, they have done the business.
Where are the 202 statement?
Let's kindly come to page 35.
35.
This is the agreement.
No. Come to the statement.
It has been sent for investigation 156.3 and it has been registered.
And you don't have a case, then you will be.
Let's see, now I am being the manager. Both came to me for against loan. I refuse you just.
Where is the statement made by the complainant before the magistrate? On the basis of which
this is basically upon this lordship.
Direct 156. 156 of the investigation sanction. Let's see. It is I understand. Now, 5 days, the present petitioner and the co-accused. Co-accused. Mr. Naik, counsel of the petitioner submits that the informant and the co-accused were the partners. They had entered into agreement. What is this? They are the part. They have entered into a partnership agreement dated 25/2/2020. In fact, the informant and the co-accused are hand in glove in obtaining the loan and subsequently defaulted in making the payment.
And accused number 2 had given a check to her.
And it is admitted fact from record that accused number 2 has check I think this is enough for the recording that we get 4:30. Next. Don't make. For that. I have written anything. I'm not assessing the converse. Then I was accusation. I was told that it was not made. And when I said I am for conversion, I will not get 6 months, will not be now. Therefore, I was. I don't understand how the stamp proposal says that in a section on 125 CRCC, whether it requires not done. As the households, it is determined whether it to CCs because the important CCC. Yes. Husband. Application was like. He examined herself under witnesses. Since having a petition for renewal, that has been allowed. The rejection was that the areas as well as the current written was to be able by Compoundable. Plus, one of the fact that the lady initiated cases against the employer told me to do that. So on the 30th of January, the court says the matter of 26th of February. I think I don't know. I am not in a position to deposit the evidence. The process I have possession and the difference may be struck off because the order has not been completed. The court allowed that. I am against that in the theoretic way. Just was it's this way. It says that is the last stop. Now, on January 30th, this order yes, very good. Exactly. Now. It's continuing. It's less a settled. Right. Idea of the exactly. What is the amount of 1 year 25? 2.5 lakhs. I go down. And if we wanted to that once we come now, we get a deviation and a correction. That I thought. Yes. Try to begin with mediation. What is that? To begin with. We don't know what is the intelligence, what is the law. Okay. Will appear on and before when? How much time will you reach? Right. We are coming now. On a door on all the remedy law. 1,000. I also thought it was come off. That's what I made it out. January, and 20th January 2018 is January. How much you will pay? 500. 27, 11, 2020. And when what is being? Okay. 20. December. In 4/2018, and we combine 25, 8, and 12. How many of you are there? 2014, sir. 2014. After getting here, how many years you are coming? Give from 1,000 people.
Six to 2013.
6
December.
December 2013. NBW 22/5/2018. 18. How many of you are there? 500.
47.
It's not a Belgian system. The petition was challenged the order of NBW that had charged in on 2018.
NBW charge now 2018. Bail?
No, my lord, this is not Belgium.
Then?
My lord, here in this case, so informant had implicated 3 members of the family, father, mother, and son. After that, the statute was submitted against.
You were abstaining?
No, my lord, I was not abstaining. Statute was submitted not against me. Yeah, after the commencement of trial, the informant filed a petition under 319 CRPC to add me as an activist. Thereafter, I was added as an activist by the London court.
Thereafter,
the
petitioner summoned during the trial of the case. Petitioner summoned under section 319 CRPC. Person should be summoned. They failed to appear before the court. Therefore, NBW on 4/9/2018 has been issued. On instruction so he will appear. 500. First.
48.
This is Belgium matter, and the petitioner Belgium along letter 18/8/2008, and the individual issued on 15/9.
Wait, you tell me.
18/8/2018.
18/8/2018. NBW 15/9/2021. 500.
49.
This case, this is also case of Belgium. Recently, Management is running case.
So you tell me the date. When
order dated 12/4/2023.
12/4/2023 NBW and bail.
Well, my 3 617 petition already rejected. Another full Jama bail order.
Tell the date.
Right. Yes.
6/9/2019.
6/9/2019. 500.
50.
This one 75/2023. And this ones are illegal below 19/12/16.
19/12/16. Bail 17/5/20. 500. Yes. Next.
Each one. There are 4.
Which one?
For 50.
Item 50. 50. Take it about 50. So, what do you want? No. 500 each. 4 accused person. 500 you pay 500 each. Total 500. 500 each. 2,000 rupees only. That's right, but paid by 1,000, make 1,000. Yes.
51.
Yes. Yes.
Double dated 3/11/2022.
3/11/22, bail,
Was earlier on jail, but bail date is
earlier bail for the 500. How many of you are there? One.
There were some,
One. Yes, make 52. 52.
There are three petitioners.
Hmm.
They were released on bail on different dates. Annexure 1 CD is the release order. Also, petitioner 1 released on 6/10/2016.
One, annexure, petitioner 1 released on
6/10. No, sorry. 28/9/2016.
28/9/2016, petitioner number 1 bail. 2 Siriki 11/2016, petitioner number 2, and petitioner number 3 14/2016. ठीक है? NBW 12/12/2022. 500 each.
Item 50.
50? Yes.
Sorry, 60. The matter was amicably settled between the parties.
They are there.
So that we will call the parties, my lord.
When? Tomorrow?
No,
Monday?
next Monday.
Monday, Tuesday, you tell me. Tuesday. 68 Tuesday. What really?
60.
Oh, entry order to continue. Entry order to
My
continue.
method, there was no entry.
No problem, you have settled whether.
I am not asking for entry.
Tuesday, we will bring them, we will pass. Finish it.
59.
By 59. Then consider petitioner seeks to withdraw the petition with liberty to
File a better petition.
or to file a better petition.
Already I have given the memo and looking. That's pardon, I think how much money I will give.
Item
42. How much?
42. It is 42 gets from going.
Item
500.
Item 55 or withdrawal. I mean
55 withdrawal. New model withdrawal. Yes.
I will sir.
Give a copy so that. Aji de diyan to. Koi problem. Madam, there is one revision. You are ready to argue that is matter there, na? No, today.
Yes. Roll over
Any mentioning?
My lord, item 72 was amicably settled between parties, my lord.
They are there.
Yes,
Coming
yes, yes.
Today.
Yes.
They have come.
Yes.
Bring them. 72 for the good. 72.
This is the affidavit and informants wakalat number.
There are two matters.
Yes. Well, first one is
Cross
second matter was compromised and it was quashed.
Okay.
Well, I have only filed a miscase in that case because the letter court will not releasing the Swiss articles.
That is separate call. Class to release kare ko?
Nine secret they poison the. They have grants to this order.
First one,
First one.
second one. The first one.
First one.
It has already been quashed, huh?
Yes.
Where is that order of quashing?
Well, first one will also make, the parties are there, will also make one.
Achha. First one, let us see. First one. What is the allegation? What are the FIRs? Terms of settlement, what are the settlement?
They are amicably settled. They are neighbors.
Staying together. Married?
No. One small boy was kidnapped. Subsequently, he was found from his own
relative source.
on his own house.
Let's see. Check it up. Who is the informant?
Yes, I am applying for informant.
Informant. You are appearing. Manumat Rao.
Yes.
And Saddapalli Shivamani,
File already.
363 আছে
take it up.
363
Who is Jamamani Gopi?
My lord,
Jami Gopi.
yeah, he is
the
the
father.
And his name is also Manmat Rao. Jami Gopi, Manmat Rao. Same.
Manmat Rao. Next. My lord, Jami Gopi alias Manmat Rao.
Then
same. 360.
363, 340.
How many accused persons are there?
My lord, initially for 7 accused persons, petition was filed. Now he is the, because he is a juvenile, my lord, his case was transferred to another state. For that reason, I have filed it.
But the other case is regarding
Other accused.
right. There at the instance of opposite party number 2, or FIR number so and so came to be registered against the petitioner and 7 others.
And so.
7 others. Full stop.
কিন্তু এটা serious allegation
Ransom amount
No,
was
but-
asked.
But see, insofar as the other 7 persons are concerned, it has already been quashed. Under section so. Insofar so 7 other co-accused persons are concerned, they had approached this court on the ground, approached this court for quashing up the FIR, FIR by filing CRLMC number 2360 of 2023 on the ground of settlement. This court, by order dated 19/5/2023. Which order? 19/5.
Yes.
9.
Was the order dated 7/2/2024.
By order dated 7/2/2024. 7/2/2024 or 24. Allowed the petition and quashed the entire criminal prosecution initiated against them by the opposite party number 3. The present petition being an accused who was a juvenile had filed the present petition separately. The petitioner and the opposite party number 2 are present in the court. Present in the court. They are being represented by their respective counsel and identified by them. They file the photocopies of their Aadhaar card to establish their identity, which are taken on the account. The allegation against the petitioner, inter alia is that on 16/12/2020 at about 7:30 p.m. The son of the informant was playing with his friends in front of his house. 2 unknown persons came near him and wanted to know about the house of his father, Jami Gopi. And then the son of the informant was kidnapped. Thereafter, ransom was demanded. It is stated that the boy was subsequently rescued after 2 days. After 2 days. 2 days. On the basis of that aforementioned allegation, the FIR was lodged by opposite party number 2. Now, parties have settled their dispute and filed a joint affidavit dated 15/4/2024. Inter alia stating that due to they are the neighbors. And on the intervention of inter alia stating that the petitioner and opposite party number 2 are neighbors, and on the intervention of the village entries, and well, we said they have settled their dispute. Opposite party number 2 is not willing to further prosecute the case against the petitioner. Nikhil Pratap, letter counsel of the petitioner, opposite party state appears and states submits that since the parties have settled their dispute and insofar as the co-accused are concerned, their cases has already been quashed. There is no legal impediment in quashing the present proceeding against the petitioner. So, next part. Taking into consideration the law settled by this court in Janssen also, and the fact that the parties have settled the dispute and filed the joint affidavit before this court, the present petition deserves merit. Accordingly, so and so.
Pardon, my lord, I am filed my power opposite party too. My name is maybe reflected.
This case, my lord, the lordship may say the release all the articles. Because the learned court below says, after expiry of the appeal period, when the matter was brought by this honorable court, there is no.
How much time appeal period?
4 months, my lord.
Appeal period.
This is the order, my lord.
See, wait. This is the statutory bar appeal period. Wait till how does it make difference?
When the court is passed, and when the matter was.
What is the
my lord,
what are the
bank
materials?
accounts, then 2 lakh or 2.5 lakhs and motorcycles. Mobile. Because there is
What
no-
is the position?
This is the order, my lord.
I think, well, they should file an application before the court below subjecting, clarifying all these facts that these are already been quashed before this honorable.
Yes, yes, that is that.
So the amount may be released. If any order which be passed, then challenging that order they should come. That is separate application. That is a
That's
separate
right.
procedure.
You file challenge that order.
Procedure is there.
Challenge that order.
457 is a file.
I number second matter I number so and so.
No, that was not filed as per 457 because.
Whatever. Let counsel petition seeks to withdraw this IA to resort to the remedy available.
Yes.
This was approved.
Mr.
Wherein I informed my lord that the complainant, that is the opposite part number 2, is admitted in the hospital and now on a ventilator. My lord, on the last occasion, my lord had.
Opposite party number 2 is the informant.
Complainant. Yes. Yes, sir.
Where is the accused?
Former judge of this court, his son, my lord, now working standing.
Okay. He is the informant.
My lord.
Yes, son of the
Father is
informant.
informant, my lord.
Son of the informant.
And whatever, where is the accused? Item?
Document.
We'll do it. Call him. Call him at what time? Where are they?
In the bar, I am not found there because of this short time.
How did
Call him. Call him. We'll do it.
he also on the committee council is
He is there, therefore I'm saying. His father is
retired judge of this court.
Let us finish it up, please. Unnecessary.
Yes.
I have to submit that it has been settled.
Please wait. Let the accused come. We will finish it up today itself. Yes. 91. 31. That was 31. Who had taken? Order I have already passed. No? One paragraph is supposed to record. Which paragraph? The same problem with you. This is the matter where I passed the order awaiting this.
Para 3 minutes.
What have you written in para 3? Now the matter was amicably settled between us. Hence, both the parties are not willing to proceed. This is the only affidavit. I don't know. I can't teach you the elementary of preparing an affidavit. I wanted to reproduce the affidavits, contents of affidavit that I have dictated. This I'll do it. Nobody in the earth, these kind of affidavits are being filed. Kind of practice is this. So anyway. Next item. Yes. 54. 18
and 19.
18. Yes, 18. Yes. Give the affidavit. Where is Subhas? I have dictated, no? Falling. Call Subhas is whether perimeter dictation they didn't. And dictation he already dictated. He did.
Already did. Recent 31 also. Recent 31 also.
Dictated, na? What are the offences here?
307 is there, my lord. One is usually grievous in nature, but in fact, they were two brothers, my lord. Quarrel between two brothers, my lord. And one injury is grievous in nature.
Whether I had already dictated the order in this case?
In this case, your lordship directed to file a proper affidavit.
Proper affidavit.
Order has not been dictated.
No, man. No, man.
Right up. At the instance of opposite party number 2, FIR number so under section so came to be registered against the petitioner. Opposite party number 3 is wife of opposite party number 2. She is injured in the present case. Petitioner is the brother of opposite party number 2. Right, 18 nature already. No, ठीक, okay. Petitioner opposite part number 2. The charge sheet was filed and charge sheet was filed on 6/9/2016, and matter is 6/9/2020, and the court below had taken cognizance of the offence on 14/9/2016. The petitioner is challenging the said order. When the matter stood thus, the parties have settled their dispute. The petitioner number petitioner and the opposite parties have filed separate affidavits.
Joint affidavit. Joint affidavit filed by the petitioner and the opposite party 2 and 3. The petition type of देखिए
Joint affidavit parties, joint affidavit has been filed by the petitioner and opposite party number 2 and 3, dated 15/4/2024. They are stating that on the intervention of the elders in the family, they have settled the dispute. Since the parties are since the petitioner and opposite parties are real brothers, and the petitioner number 3 being the wife of the opposite party number 3, being the wife of opposite party number 2, they don't want to proceed with the criminal case registered against the petitioner. All the parties are present before the court today. They are being represented by the respective counsel and identified by them. And to establish their identity, they have filed this self-attested photocopy of the Aadhaar card which are taken on the court. Taken on the court. Mr. Baroda appears for the case and submits that since the parties are belonging to the same family and on the intervention of the elders of the family, they have settled their dispute and filed the affidavit before this court. Affidavit before this court, although one of the injuries
Grievous
by the opposite party number 3 is grievous in nature, but the opposite party number 3, who is present in the court, states that he doesn't want to proceed against their own brother-in-law in the present case. Therefore, there is no legal impediment in question hereby. Taking into consideration the law laid down by the Supreme Court in Jansen and the fact of the present case, required to squash.
32 minutes.
32.
32.
It's all 32 is there, na? Yes. 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 What are the allegations?
Allegation 341, 354, 394,
Allegation. Section don't read the section.
Allegation is that at the time of when the victim went to the tuition, at the time of the accused was outfitting her in the trying to outraging her modesty. This is the allegation.
Yes. Yes, Mr.
Yes, yes.
Maharaj.
The 506 actually.
And the informants are
As a country.
mother who
Where are they? Sulochana Lenka.
Sulochana ki?
The mother. And Namita Lenka.
Victim.
Accused is Narendra. Rana Singh. Only one accused. Right. At the instance of opposite party number 2, FIR number so under section so registered against the petitioner. The allegation against the petitioner in the FIR, allegation made against the petitioner in the FIR was that on 31/7/2011.
Sign करिए अपन तभी 10 कर attested
the petitioner embraced the opposite party number 2 and opposite party number 3 and lifted her in an auto by telling not to shout. And at the same time, passerby intervened. Passerbys had intervened and rescued the opposite party number 3. On the aforesaid allegations, the FIR was lost. After investigation, charge sheet was filed on 1/8/2011. 1/8/2011. 1/8/2011. And the court below had taken cognizance of the offence, cognizance for the offence and cognizance of the offence on 24/3/2023. When matters stood thus, the parties have settled their dispute. They have filed a compromise affidavit dated, separate compromise affidavit dated 15/4/2023, which are taken on record. Taken on record. In the affidavit, the opposite parties have entirely stated that on intervention of the elders in the family and the village entity, they have settled the dispute, and the don't want to proceed against the petitioners. The petitioner and opposite party number 2 and 3 are present in the court. They are being represented by their respective counsel and identified by them. They have also filed photocopies of the respective Aadhaar cards, which are taken on record to establish their identity. Mr. Maharaja appears for this case and submits that since the parties have now settled the dispute and filed affidavit before this court in this regard, and the parties are present in the court, the opposite party number 2 and 3 are not willing to proceed against the petitioner anymore in view of the amicable settlement between them. There is no subjecting the petitioner to the trial, maybe a futile exercise. Therefore, in view of the law laid down by this court, law laid down by the Honorable Supreme Court in Gantz and so on, so this court can give indulgence to the taking into consideration the statements made in the past and law laid down by the Honorable Supreme Court in Gantz and Supra. The petition deserves merit. Accordingly, the so and so was.
Yes. 64.
54. Sorry?
Notices have been issued to opposite
Let's
party.
see, check. Notice. Not sir?
No, not at all.
Not sir. Awaiting the notice, service of notice on opposite party number 2, adjourned to. Yes. Was there an interim order?
Yes, my lord.
Interim order to continue. Interim order to continue.
56.
Land Council for the 56 Land Council for the petition seeks time to remove the defects pointed out about SR within 1 week. Leave the matter.
58.
Yes. Password.
60.
I'm appealing for the OP number 4. Today I have tried
So and so enters appearance for opposite party who and enters his appearance, file the Vogatnama and seeks time to file objection. Release the matter.
63. 63.
None appear.
None appear.
None appear. In the interest of justice, adjourned to July.
Yes. 64.
Yes.
Here, the last particular, the also said, directed to file us, directed us to file as to the members comprising the fire safety committee. We have filed an additional affidavit to that effect.
Inquiry has already been conducted and the report is already, you will be filing the report. So before this report, during the course of the copy of the same. Yes, Mr. Mara.
Flag D. The affidavit is flag D or also.
Flag D.
Yes.
Yes.
The lordship takes page 4 of that affidavit.
You got it, Mr. Mara?
My lord, I have received the their affidavit they have filed, I will take inspection on this.
Pursuant to the order dated. Pursuant to the order dated. 8/1/2024. The petitioners have filed the affidavit dated. Affidavit dated 8th April 2024. A copy of which has been supplied to the legal counsel for the state. Mr. Maharaja seeks time to get the instruction on this matter. We'll give it.
Take time.
Yes.
65.
65.
Adjourn.
66.
66.
Yes.
On the ground works, it's not for 2 to 80. So one is diagonal, so 200 year very old age works. 95 years, it's not for here, it's not 2 is 80.
No.
Notice was issued.
You are. Notice has already been issued.
Yes, and 21/3/2024, he was directed to file a fresh report.
No, you have filed. Let's see the service position.
21/3/2024. 66 item. এটা সেটা মোটা পাইতে 60 এটা হচ্ছে 4762 4762
Not written. Not written. Just delivered, but nobody appeared. It did not return. Item delivered. Nobody appeared.
Ready?
এটা আসলে আরেকটা ডিসকাস করব
It did not return.
Simply adjourn. Give it. Yes, sir. Next.
67.
Yes.
Sixty-seven.
non-applicable. Let it be urgent.
None appears in the interest of justice. July.
Correct. 58 was supervised. 58 was supervised.
What are the
50. Okay, 60.
69.
68 urgent.
68 already. 69.
Accounts for the petitioner seeks time to cure the defect pointed out the SR. Please the matter. Yes.
70.
Item 7.
It is more normal.
Matrimonial disposal.
Urgent.
Serial number on the condition that the all the cases will be closed. Because this case will not be offered 307. So without approaching this.
Call them.
The problem is that the wife was now after marrying second time living unless
I'll simply issue notice. Issue notice in the Nagnam state. Part only Mr. Deepthiranjan Mahapatra appearing for the petitioner submit that the parties have already settled their dispute, and on the basis of the petition filed by the petitioner number one, petitioner number 1, and opposite the marriage of the petitioner number 1 and opposite party number 2 has already been dissolved.
I annexure 4 of the.
Resolved by annexure 4 of this petition. Issue notice to opposite party number 2, so and so, returnable so and so. In the meanwhile, the proceeding is so and so state.
71.
69.
I filed an application for. I filed an application for vacation of state. And taking advantage of income. Let it take up tomorrow.
We will see. I'll give you date. Okay.
My lords, I appear in serial number 69. My lords,
It is urgent. A date will be given. Yes.
71.
So, entered appearance and file Bokaratnama for OP number 2, 6 time to file response to the petitions.
73.
May it please your lordship. Item number 73, my lord.
Yes.
Your lordship, previously your lordship directed, may kindly peruse the previous order, my lord. Paragraph number 5. Learned counsel for the petitioner submits that he would be moving an application before the court below, seeking an adjournment owing to the fact that the matter is sub judice, my lord. Here, your lordship, we move.
It's all right, but tomorrow I will pronounce that judgment.
Your lordship, stay is required, my lord, because stay on the further proceeding.
Tomorrow I'll pronounce that judgment. I have already finalized that, and if any benefit comes from the judgment, then you'll get a stay.
Grateful. Grateful.
Monday. You file the affidavit. Monday. Monday. Yes.
Grateful.
but my lords, here, my lords, I'm actually. My lords, here, serial number 69. On 69, there is a matter today of Dhyan Foundation, my lords. A similar identical matter, my lords, it's a different matter, where my lords was pleased to issue notice to opponent.
69 is not Dhyan Foundation, it is something else. You are appearing in a wrong matter.
Okay, then my lords, 73 only. It's 73 only, where Mr. Sahu had just appeared. My lords, what I am only seeking is, my lords, I do agree, my lords, in the earlier matter, my lords had reserved the matter for orders. My lords, but what happening is here, my lords, the other side is.
Tomorrow the judgment will be pronounced, therefore I am keeping it on Monday.
But my lords, this matter is not connected with that matter.
Let us see, I will examine on Monday.
My lords, the police have come in my Goshala and they have threatened me that they will take the cattle forcefully.
I please read the judgment tomorrow, which I am going to pronounce. If any benefit flows from there, then you are entitled.
But my lords,
no benefit, then
my lords, may I only request that status quo to be maintained till then. The other side.
For status quo, I have to hear it. Don't precipitate. Why are you precipitating? No, 72.
73.
Don't precipitate because I am pronouncing a judgment tomorrow pertaining to the same Dhyan Foundation. If any benefit flows to them, it's a different story. If no benefit, then.
We have purchased those cars. The fact finding there is no cruelty. The veterinary doctor has examined the judgment. It is in the judgment itself. It has been specifically written down. And the cows are given on the Zimanama and the cows are set with them. We have paid them for the entire period that they have kept it with them.
Let it be there till Monday with them.
All they're asking is that the cows be returned to us because they are using it for a.
If that order is there, it will be returned to you. Don't forcefully take away. Let us see.
No, we are not.
Order is there. We'll see the order.
Yes, sir.
Okay. Take it.
But my lords, if protect me.
Yes. Give a copy to them.
We will. Not there. I'll try and find out.
Who is there for you, Mr. Gupta?
Well, for Mr. Tirsahu appears. Mr. Tirsahu.
Pardon your lordship, I am appearing in the.
Both of you are not reachable.
My lord, I am in item number 73, my lord. I am for the petitioner.
You, Mr. Sahu, you please collect it from Mr. Patnaik's office.
My lord, I will collect, my lord.
Okay.
But my lords, may I only request one thing. The statement given by the opponent, my lords, that may be came to be recorded.
Don't do anything. Believe him.
Okay, my lords. I'll
Believe
do.
your friend.
Yes, I'm obliged.
74.
Pardon to mention my
67.
For modification of order.
My lord, pardon to mention.
Keeping in the view that logistic kindly pay. I am bail, broke the bail for the law is also to the judgment order passed granting the cannot remove magistrate parties are rendered an order in the absence of any revision, any absence of any express provision.
Where are you reading? What are you talking?
That's it, senior, okay, on the bar, senior member of.
What happened? What are you reading?
I have filed an application on the section 439(1)(b) before the president for modifying my bail condition.
Which are the conditions? Show me which
Condition.
which page?
To understand high.
Go slow. Otherwise, it's very difficult to understand. Yes.
Page 40.
40. Okay. What is the condition?
Let's say after paragraph 5, serial number 5, beside the conditions of the provoker punishing bank guarantee of rupees issued by the defendant for a
Condition
period of
number?
1 year.
Condition number?
Condition of 5 thereafter.
Accused Prabhakar Karan shall produce the original of all the money received before the IO within 7 days.
No,
From the
page 40.
40 only. I am.
40.
Which condition you are talking about? Besides this condition.
Besides this.
Accused Prabhakar is also furnished bank.
Similar matter, let's see how the already disposed of.
Facts of every case is different.
Similar fact because land was acquired in the year for the new capital Bhubaneswar city. Thereafter, this FIR is completed first. Till date, they have not failed to injure cities. Since last 10 years, have been first. They have. That's it has not been filed. That's if I have already understood all the other orders, vendor orders.
That's right, but see here in that matter there was no opposition. Now there is an opposition. What to do?
That is not different. These are similar matter. They have filed another FIR. It's a second FIR in a similar case. But see, my kindly say under order city there is no final chapter to file appeal dates. And it is a old one. Let's say kindly turn to Answer C. He suffering.
What is the amount involved?
Amount is about 1 crore something. He has a landed property at Bhubaneswar. And there is no, suppose he is unable to give the treatment, also take a hand loan. And I pray that Lordship may give any condition, I will pay, give property security instead of bank guarantee.
Your Lordship may kindly have a glass to running page 23. Last part. This petitioner has received the entire amounts of the landlords by forged signature. Your Lordship may kindly have a glance to page 23. Page 23. Your Lordship may kindly have a glance.
No, I understand it. Allegations are very serious. Now bail is granted. See the onerous conditions. The Supreme Court in many judgment has said that onerous conditions, on the basis of onerous condition, you can't, encroach upon the liberty of someone. So
the amount which has been received by
an alteration of that by only the property security. I'll increase the.
As because the London trial court has imposed this condition, as because this petitioner has received the 10 numbers of your Lordship will be satisfied if your Lordship perused page 23.
Yes, I'm there in
page 23, middle paragraph. Middle paragraph.
On inquiry.
I may be permitted. On the inquiry revealed that the payment notices to the landlords were served to Sri Prabhakar Karan advocate, present petitioner, my lord, instead of the actual awardees. Sri Karan had submitted authorization of the awardees in form of affidavit before the notary. Out of the total 29 paid vouchers, authorization in 11 vouchers were sent to the GEQD examination, along with the sample signature of the awardees, namely Sri Hare Krishna Pahad Singh, Suresh Chandra Pahad Singh.
Yes.
Your Lordship may kindly have a glance.
Yes, I understand it.
Entire payment is with him. Only if
No, your signatures are confirmed and all. See, don't go by that. You have the fact of the matter is you have taken the money. You are the lawyer. But being a lawyer,
Yes. How this person will get back their amount if this condition will be waived? Your lordship is to
what
decide.
is recovered from his house?
Recovered this amount, all the passbooks and accounts, and the account has been free.
No money is recovered.
Yes, some money recovered. And charge sheet has already been ready.
How much?
Charge I have not received the entire information. Charge sheet is made ready since 27. So if your lordship keeps it to third week to 17, I will the charge sheet copy will be supplied to all the accused. There are 5 accused persons. Land acquisition officer 2 numbers. All wear hands in glove with each other, my lord. So your lordship.
They suffer by the petitioner, so 80 years, more than 80 years old man. And I
80 years.
for the treatment. I made money for my treatment. What's my kindly?
How these persons will get back their money?
Right. It is not recovery proceeding. See, he first of all he is a lawyer. Second, he is 80-year-old man. Third is the condition is onerous.
If your lordship considers that the
Bail and the bail generally this condition shall not be maintainable. That's the Supreme Court says no condition should be imposed. Cash condition and all. So therefore, I think we should.
As your lordship deems, I
let him give property security.
Property security. This amount, how this amount will be paid to the losers, land losers?
See, criminal cases are not meant for recovery, sir. If he has committed some mistake, he will go to jail. He will be hanged.
Land
But
losers.
can you use criminal prosecution for these are not arm twisting method of.
Out of that amount only, these land losers will get their amount back after the trial is over, my lord. My submission is that. So that the trial court has imposed this condition for a bank guarantee.
Therefore, he is giving property security. If they are convicted,
Property
the property will be put to auction and whatever money.
And that will time taking, my lord. That will be time taking, my lord. So this amount can be disbursed to the land losers if they adduce evidence before the court.
Even suppose this money is taken and even eventually he is executed, then how will you recover?
No, this money
That is also another aspect. Suppose you take this money of 20 lakhs, disburse to the land loser, thinking that he is the culprit. Ultimately, he is executed.
No, just now it is not going to be delivered. After the trial is over.
Therefore, property security.
Property security, my lord, it will
be. He is an 80-year-old man and is a lawyer. Let us be practical. Sure.
Charge sheet is going to be supplied within a week.
Okay, the petitioner has been enlarged on bail by the court below by the order dated 6/4/2015. You are already on release on bail.
6/4/2015.
But you have not deposited the amount so far. 2015.
Bank guarantee has been deposited.
Bank guarantee have already given. Then, if you have given already. No. If you have given already, you are
That has been given and renewed time to time.
No. I thought now you are still in the jail, so therefore I want.
No.
Given it.
Kindly see my conditions.
Whatever
80 years old, I am suffering.
Somehow,
So I will be completed. I will no more.
No. You took the benefit of the order. Now you want and
before 2011.
I thought this.
What happened? Just giving you notice. Before 2011, that the land acquisition amount, that amount is paid to the lawyers.
Whatever. I am not going to the merits of the case. 2015, the order was passed. You furnished the bank guarantee. You were released on bail. So now you are coming after about 8 years for release of that bank guarantee.
Another matter, I came before this report twice. Thereafter, that is not disposed of. Then matter was lingering. Suppose one.
Talk about this matter.
No, that's another matter.
No. Talk about this matter.
These matters.
Why have you come after 8 years?
Because
for modification. Why have you come?
He seriously because since last.
Petitioner was
kindly consider because due to his illness, he is suffering a lot. He has taken some hand loan. Second,
nothing, no material is there, nothing is there.
I see the additional 6 entire documents is there, medical document.
medical document nahi, you take in hand loan and
That
all.
document I have got exhibit, but medical document I have.
You, then you move appropriate application before the court below once again. Write down.
My appearance may kindly be noted. Sanjay Kumar Das, Standing Counsel, Vigilance.
Sanjay Kumar Das. The petitioner is has been enlarged on bail by the court below by the order dated 6/4/2015. 6/4. The petitioner has filed the present petition challenging one of the conditions by which the court below has directed him to furnish bank guarantee of 20 lakh rupees. It is the matter of record that the petitioner had already furnished the bank guarantee and he was released on bail. Of late, on file किया भैया on 8/1/2024, the present petition is prepared. Mr. Sanjay Kumar Das, the Special Counsel for Vigilance, has vehemently opposed the prayer. Then Counsel of the petitioner submits that the petitioner is terminally ill and he is 80 years old. He needs desperately money for his treatment. However, and he has also obtained hand loans to meet the expenses for treatment. However, not a single document is filed in this petition. Therefore, the petition is disposed of with liberty to the petitioner to move appropriate application before the court below for the purpose of variation of the order dated जो bail दिए था ना variation of order dated so and so. If such application is moved, same shall be considered on its own disposal. Yes, next.
Hon'Ble.
75.
My lord, kindly have gone through Annex 2, running till 17.
2,
Running till 17.
17. Yes.
The bail application of the opposite part number 2 and 3 were rejected by the Honorable Court, and this Honorable Court, Justice Junior Singh, distinguished the case of the opposite part number 2 and 3.
Please don't take the name of a judge. Huh?
Well, rejected the bail application.
Everyone is High Court only. Yes.
Rejected the bail application of the opposite part number 2 and 3 and allowed the bail application of the co-accused Nandini. And I have granted to
Nandini is granted bail, the other accused person bail is rejected.
and kindly have granted to the impugned order. That is Annex 3, 11th page 21.
21. Yes.
Lord trial court, considering the case, Nandini already released on bail from the High Court, granted that.
You want cancellation?
My lord.
What? Somehow he got the bail. One of the
On merit, considering this Honorable High Court.
Nandini is a lady.
Nandini is a lady.
Or the other two accused persons have been granted bail by the coordinate bench.
Other two coordinate bench rejected the bail application of the opposite part number 2 and 3, whereas granted bail to Nandini advocates he is a lady.
Right.
But trial court below granted bail to the opposite part number 2 and 3 as because Nandini released on bail.
Let us see the High Court order.
My lord.
Does he say that case is made out? Where is that?
My lord, page 17.
17, huh?
My lord.
Yes, let us see. What are the...
It is submitted paragraph 4. It is submitted by the Learning Senior Counsel that petitioner in custody since 3/7/2022. That sheet has filed since 29/10/2022. That further continuance in custody is unwarranted. It is submitted. It is submission of the Learning Senior Counsel.
On perusal of the statement of the state charge sheet, witness number 1, it is clearly borne out that all the petitioner in a conjoint manner assaulted the Pinto South was injured, and this was further so and so. Hence, the submission of the counsel for the petitioner that there was no pre-mediation. There's so and so. Considering petitioner,
it is also borne out from the record.
so, it's all right. All of them are having the same role.
But this Honorable High Court rejected the prayer of the.
See, the charge sheet is filed on 29/10/2022. They are in custody since 3/7/2022. Now it is 24. How about 2 years?
But
What are the offences?
Please note. My grievance is where Honorable High Court considering the case of the.
Once High Court rejected, is there any res judicata?
Yes, my lord. Judicial propriety should be maintained.
What property? That order was passed when?
It should be considered.
When did that order was passed?
That order was passed.
28/2/2023. Now the trial court.
Trial court 16/11/2023.
8. After about 2-3 months.
Yes, judicial propriety should be maintained. But the High Court refusing.
What is the stage of trial?
8 witnesses have been examined and they all corroborated the prosecution.
Where are those evidence?
That I have not asked because.
What are the materials which have come on record insofar as these 2 witnesses are concerned?
Lordship, may I have page 21. It mentions
Page
the
21, huh?
21 of the file.
Yes.
The order mentions the
Yes.
the number of witnesses.
Please read. Please peruse the case record.
Peruse the case record, connected document. This is the second successive bail application for the accused. The accused has in custody since 3/7/2023. Trial of the case is going on. In the meantime, 8 number of prosecution witnesses have been examined, whereas prosecution has given list of 40 witnesses to be examined. In the present circumstance, that is least possibility of completion of trial in near future. On the other hand, this court feel that accused have learned their rigorous of law while in jail custody. Above all, another accused, namely Nomin Sahu, is already released on bail on 4/3/2023 by the order of Honorable High Court of Orissa. Most importantly, counsel for the accused submit that they will remain present in the court on each date of hearing of the case without fear. Considering the above pro and cons of the case, sitting at par with the other accused, the petitioner not on at par. This court is not inclined to release them on bail. Hence, is inclined to release them on bail. Hence, the bail application prayer of the accused is out.
High Court rejected 8 months, about 3-4 months back.
My humble
Thereafter, they have moved the application and 40 witnesses. Trial court says 40 witnesses are there, only 8 witnesses are examined.
But the trial court has not analyzed the witness have supported the prosecution.
They are already released.
They have already released.
So I will issue notice. Let us issue notice to the accused. Obviously, the accused has to be heard.
And my another submission was that since the bail application of the petitioner was rejected before.
Once it rejected, High Court rejected, doesn't mean that they can't get bail for a lifetime to come.
No, I am not.
3-4 months back, the High Court rejected. Thereafter, trial court applies the mind and gave the bail. It's all right, granted bail. Why should the court will interfere to cancel it? I am just issuing notice and release the matter in July. You simply issue notice, release the matter. You are appearing?
Through registered court.
Okay.
Well,
yes. 1 minute. What happened? 95? Okay, parties have come. Okay. 95. Let us see. Parties have come. Yes. 95. What is the offense? 420. Okay. 420. It's all right. Allegation? Okay.
In front of hospital,
Yes.
his son is present, madam.
Acha.
Retired judge.
Okay. Madam, at the instance of opposite party number 2, FIR number so came to the register against petitioners. Petitioners. When the charge sheet was filed, investigation over, charge sheet filed. When charge sheet was filed? After investigation, police filed charge sheet on such and such. The allegation against the petitioner of that day, we heard that on 16/7/2022 at about 1:30 p.m. The allegation is that the present petitioner committed fraud by way of cheating by impersonation and perjury of a valuable document by utilizing the same as a genuine by entering into a criminal conspiracy with sub-registrar Jagatpur RI and other staff and staff and sold the property to one Harihar Patnaik and one Arjun Kumar Mahanti, and misappropriated the sale amongst them to the tune of 98,500. When the matter stood thus, the parties have entered into a settlement and they signed a compromise deed dated 28 compromise deed dated
29 December.
29 December 2023. On the basis of the said compromise deed, which is placed at Annex 2, so the petitioner seeks indulgence of the court and quash the entire proceeding. It is stated that the opposite party number 2, who is 81-year-old man,
and hospitalized,
and is hospitalized, and his son, Mr.
Chaudhary Satyajit Mishra.
Chaudhary Mr. Satyajit Mishra, who is a practicing lawyer of this court, is present in this court. Petitioners are present in the court, represented by their counsel and identified by them. They have also filed the self-attested copies of the Aadhaar card to establish their identity to which they are taken on the court. Where is the affidavit? Affidavit filed? No. Okay. Mr. Ragada appears for the state and Mr. Nikhil Pratap appearing for the state submits that since the dispute is the intrastate party and regarding the sale purchase of the property in subject and subsequent to the registration of FIR, the parties have settled their dispute and then entered into a compromise and the compromise deed dated 29/12/2023 has been placed on record. On the basis of the said compromise, since the parties are seeking quashment of the criminal prosecution, there is no legal impediment in quashing the same. Regarding to quashing the same, taking into the aforementioned submission at the bar and fact of the given case, the FIR and so on and consequent proceedings arising there somewhat. Yes. Next. 50%.
76.
Challenging the criminal proceeding by under section 220, 191, 342, 505.
Yes.
506.
I have a submission, Your Lordship. I am in DC. I have a submission in this matter, my lord. I am in DC.
Yes, Mr. Sarangi.
In these three cases, I appear for the informant, my lord.
Yes.
I appear for the informants in these three cases where stay is operating against me. Against the order of cognizance, they have come before this honorable court challenging the same.
Yes.
My problem is, Your Lordship, I am not able to attend the court, honorable court, my lord, and assist the court because of my personal tragedy. So may I pray your lordship may take it up next week, Tuesday or Wednesday, any day.
Case of Mr. S.K. Shodangi, appearing for the opposite party, leaves the matter and also entry order to continue.
Petition number one, the victim one is present in this court, my lord. Initially, my lord, on 11/5/2012, my lord, initially petition number one lodged affair against father-in-law, mother-in-law, under section and our husband, 498, 294, 323, 506 and 34 of Indian Penal Code. Thereafter, after 1 year, my lord, father-in-law lodged affair against daughter-in-law and other family members, my lord. And that has been watched by this Honorable Court by Honorable Justice S.K. Sahu, and it has been mentioned, taking account the nature of accusation.
Then why 3 matters? Why 3 matters? Why 3 matters?
Accused for different accused persons, my lord.
There is a matrimonial dispute.
No, my lord.
Initially, it was matrimonial case. FIR was issued by the corporate.
All these issues may be taken up next week, your lordship. All these issues may be taken up next week.
But he has a personal difficulty.
He is also present. Then what he said probably.
What do you want?
Then he says file an affidavit that will be part of the record.
Okay, this affidavit.
Also, red chat and affidavit. And order of this Honorable Court in respect of other counter case.
Okay.
That has been got by this
the petitioner set up documents along with the date chart. The same may be the same.
And also affidavit is
same is taken on record.
affidavit by the petition number one.
And affidavit of will taken on. Leave the matter on the request of Mr. Shodangi on Thursday.
Your lordship, direct.
The victim and the person is present in person. Your lordship.
Right, record is there present. Give in writing who are present. So and so present in person.
My lord, may direct to solve the copies.
Pushpa Rosalina, he is present.
He is present.
My lord, may direct to solve the.
Why unnecessary she is coming?
My lord,
This is because of peculiar circumstance, probably by not.
Peculiar case, my lord. On 11/5/2000.
No. Why she is appearing? Peculiar thing you will take care. Why the parties are?
Husband told her, we will decide to compromise all the matters.
And then I'll send it to mediation.
Subsequently, my lord, she went to the court and not deposed against them, my lord. In 198 case, criminal case, entered in acquittal, my lord.
So sentimental.
Thereafter, not open to us.
Take her that the matrimonial.
Thereafter they.
The other suit, which was dismissed at the instance of the husband in the lower court, he filed appeal. The lady did appear also because of her.
I know, I understand it now.
Because of promise given by the court.
Expected decree was passed.
So why now is there any chance of
I have
settlement?
filed all the documents.
Now is there any chance of settlement? Now keep on fighting for.
No, only to pass.
Shall I send it to mediation? All the matters.
This honorable court already passed.
I am asking something else. Why are you complicating? I understand it now. I understand it. But the fact of matter is now your husband is cheated. Husband said that you please cooperate. I'll do X, Y, Z. And he did not contest the petition. Got the divorce. Now turning around and filing cases and all. Everything runs around on these facts. So why can't you go and settle the dispute for all times to come?
They are not cooperating.
Mr. Shodangi,
My
there
lord.
are allegations against your clients. Why can't you go and settle the dispute?
All these allegations, your lordship hears me next week, my lord. Your lordship may change your mind, my lord's mind. Your lordship may free to pass any order after hearing me.
Yes. Okay.
My lord, may direct to solve the copies that you filed today.
Give the copies so that it should not.
I filed lordship kindly.
The criminal case entered in.
I have handed over.
Because of her deposition. Everybody, the divorce suit is allowed. So the counter case which has been filed at a belated stage, it is pending for which we have come for passing. That is also.
Okay. Come to 77.
77.
Item 77, my lords. My lords, on behalf of my senior, Mr. Kanungo, he is on his legs before another court. My lords, kindly pass over the matter.
Pass over.
Pass over if possible.
No, pass over at the moment. Urgent.
My lords. My lords. My lords, may I then request a short date for the matter?
78.
I'm deeply obliged.
Which one?
78.
Yes. you are
78 adjourned.
Due to technical problem, we could not, due to technical problem, we could not attend to receive.
Who? Who?
Mr. Gulab Khan. In this case, I'm getting.
Oh, adjourned then. Huh? You can't decide the case. Once he can't appear, he can't appear. Oh, list it. As per. Yes.
79.
My lord,
नहीं वो सेटलमेंट 79 हाँ हाँ चलते
80.
80
Adjourned. 80 years. Yes, sir.
And barely after 1 year, he suspected because illicit connection of his wife with his brother-in-law. And that's
Brother-in-law.
In debriefed state, he started scolding and beating his wife also. So thereafter, the wife left his husband, along with his son, and stayed in his parents' house. That's opposite party number two, the complainant, very ill, requested to wife to accompany with him. Neither the in-laws nor the wife wanted to go with him. So thereafter, he approached the police station. The petitioner is a police officer. At the relevant time, he was the SI of Hapur police officer. That's the record the station diary on being approached by the complainant. That's then, because it's a spousal dispute, he wanted to resolve. He wanted to resolve the dispute, he informed the in-laws. And so the complainant also told him come the next day. They came the next day, the complainant as well as the in-laws and his wife. Because then it failed with us. Despite of frustration, the wife of the company number two did agree to accompany with him with his son, not the in-laws also, because he was beating and he was not at all he was not agreeing to go with her. So that's what the petitioner recommended or taking that you will be permitted to visit your son from time to time. So that is he didn't sign. She will not left. Thereafter, he wanted to make out a case against this police officer that he beat him in pipe, all that. And thereafter, he approached this court in a here and MP bearing number 1784 of 21. This Sunload was pleased to direct the SP to consider the grievance which he has made for registration case. Case was registered. Investigation went on. And after conducting investigation with supervision by DSP, what was recorded with all persons, the wife, the in-laws, the neighbors, the nearing shopkeepers going to, and nothing was made out. And ended with the final report. No case made out. And this was also with the approval of the police superintendent, police. After this, complainant filed a protest petition by the complaint petition. And the SDGM Dhankar without considering any statement recorded in investigation, all that, ignoring all that, based on preliminary statement, proceeded to issue procedure against the present petitioner. Now, my humble submission is for RCB and the magistrate in the Cognizance order, I refer to two Supreme Court decisions and a few judgment and the magistrate appears to have been oblivious of the recent judgment of Hon'Ble Apex Court in the case of Devaraja, and so many judgments are high courts. So for a police officer taking cognizance against my humble submission, I have given a compendium of judgment for RCB. This is in fact what I ran into.
Who is appearing for the opposite party number?
I am appearing. Information.
What is the proposition? Sanction.
Sanction. Exactly. For what my humble submission is, these are not that is unconnected with the discharge of duty of police officer. Because the station diary is recorded, there is station diary entry, and also to resolve the dispute, the spousal dispute, the police officer made all attempts to resolve.
I'll tell you the interstate dispute between the parties, matrimonial dispute. This police officer is intervened. and the capacity of a police officer.
Yes, sir.
And he might have crossed the limit
Yes, sir.
while on his no, what he did, I am not interested.
Yes, sir.
He might have crossed the limit while exercising his duty as a police officer, for which you are trying to prosecute him. You prosecute, no problem. Very the sanction.
Sir, my lord, Lordship kindly turn to the imbuer. As an annexure to the repetition to the CRLNP, where the police are called twice to the police station to the petition. To compare. On one occasion, he returned. Now your wife has not come, you come tomorrow. Tomorrow morning he
If you would not have been a police officer, you would have gone there. So he is using his office.
Yes, if everybody is present, he has written in animal like manner. My lord, Lordship kindly see the photo. My lordship, it is private misconduct, just not any official duty. No one has given any a pad.
Annex of 3 by lordship kindly. So the injury report. Annex of 3 at page 27.
Yes. Received requisition.
Page 27. There was no sign of visible external injury. My lordship finds from page 27.
I am there. There is no sign of visible injury.
Can you see the annexure?
Annexure?
Page number 6 of my counter. Written like animal, I have given the photo.
Annexure 6.
Yes, ma'am. Annexure A by 2, A by 1, page number 6. At my counter.
Written black and white.
My color photo I have. I can show Lordship.
But how the doctor has given no injury?
My lord?
Doctor has said no injury. Injury report.
My lord, injury report, doctor has not said it is. I'm telling you. Just a second. Where is injury report? Page number
27.
Not annexed to my.
No sign of visible external injuries.
It is not annexed to my petition. Injury report is not annexed. It is not available with my petition. The office of
Total 49 pages.
Yes,
49 pages. This is your counter you are reading.
Yes.
Please see the counter.
Without having full paper book, and you file the reply also. You have to meet this. If you are showing the photograph that you have been beaten profusely, whatever, and then that has to match with the injuries. The injury report says that there is no injury at all.
It is very sad because this is the photographer. Lordship kindly see. On the relevant day.
Which I will believe, the photograph or the.
Lordship kindly take up next week and come with the better reduction. Because it is a
But even in the custody, if somebody has beaten you.
I was in the police station. I was in the police station for 2 hours. Drilling, inhumane drilling and beating.
Rightly, your lordship said, even if that is some excesses, there may be.
But beating is no excess.
There are cases where your lordship will find.
Whether it is coming under the color of duty or not.
Yes, sir. Even in case of death also.
Custodial.
So this has to be established. Whether there is a link between the action.
Yes, Mr. Ragada, what do you say?
What are the while taking cognizance?
Forget about it. Can you prosecute your officer without sanction in these kind of facts?
Since this is arising out of a complaint case, madam. But in fact, madam, sanction is required so far police officer is concerned. But if he exceeded his jurisdiction, my lord, assaulted, my lord, that is not his due discharge of a duty. Then cognizance can rightly taken, my lord. If he shown that the due discharge of a duty, these things have happened, my lord, then only, my lord, the case can be quashed.
Interrogation over the
So you filed
limitation also.
Better.
At the request of the counsel for the opposite party number 2, adjourn the matter to censor, interim order to continue.
Interim order will be given, my lord, because.
Interim order to continue.
Yes, sir.
Yes.
81.
Madam, item 81, Madam, I'm appearing for the private respondent. Madam, may I kindly have a glance at the last order, Madam?
Yes. Yes.
My lord, may I kindly have a glance at the last order, my lord?
Yes. In the meantime, we are going for the opposite party bank requested. Which order? Last order means last order is simply urgent.
My lord, my lord, they were directed to produce the vehicle before the concerned IIC Keonjhar police station.
Which order? Which order
My
you are
lord,
talking?
it starts from the order dated 16/11/2023, and thereafter with subsequent amendments, with subsequent orders of not getting the vehicle arrested or otherwise. 16/11/2023, my lord.
No, last order is 22/02/2024.
Yes.
No,
And
in
after that, my lord, the police has been complied the order of the honorable court, my lord.
22, yes.
Yes, my lord, they were directed to produce a report of the
complied.
vehicle.
That has already been done, sir.
My lord, the noting did not show that, so they had to produce a report before your lordships to be convinced that the vehicle is there. Admittedly, the vehicle is a hire purchase agreement, which is leased out on our name, and we are the owners, being the financers.
Submit my lord and fix up.
Right, your lordship. But my
Ready
lord,
or you are taking time?
no, my lord, I'm ready, my lord. I'm ready, your lordship.
Yes.
Your lordship found that the order has been complied.
Hmm.
Because the last occasion, this is nursing said that to show your bona fide, where about your vehicle, you produce before the police station and get it. That is why. But that order could not be complied because that was the wrong mentioning of the, supposing the order was passed on this date, it was directed to be put up before a date. So that is why to, for the.
Anyway, it is complied now.
It is complied. So case is now, the cognizance has been taken and this is a loan matter. The SDFC had given some loan amount for purchase of the highway truck. So after payment of some installment, that will have to be default. So that is why the notice has been given once. That is not there in the record. So just asking my friend. But however, that is a separate thing. They have taken already contemplated action on the surface area. So that was given a go by. So complaint was filed, and it is absolutely a contractual matter, and cognizance has been taken. If the lordship will find the complaint allegation, may I draw your lordship's attention to 11, page 11.
11.
Yes. On the basis of the complaint, we forwarded to police that was registered as the affair. And in the meanwhile, the charge sheet was submitted. Then the cognizance has been taken, and the cognizance order is, that is.
Now let us read the complaint.
Yes.
From, see, the test is in the complaint.
Yes.
If, or the FIR, whatever the charge sheet.
So,
if prima facie case is made out, cognizance can be taken.
Yes.
And whether prima facie case is made out or not.
Or the only by humble submission is that it is a contractual matter. And for recovery of the loan, the procedure has been provided on the Surface Act, or either you may file a civil claim. But you cannot file a complaint case which is completely involved in civil.
Who is the informant? Bank?
Bank is the SDFC bank is the. If there is
Who is this
procedure
gentleman?
already
Who is this gentleman?
My lord, I'm appearing for the bank, my lord. My lord, I'm appearing for the bank.
So may I just read out the.
Legal manager come principal officer SDFC bank.
Yes,
Yes, your lordship. I'm appearing for the bank, my lord. Right now, the person who had sworn the affidavit then is no longer in service. I'm representing the bank's interest.
I have not finished my submission.
No, I was.
See, the dispute is arising out of a default on the loan account.
My lord, your lordship is absolutely right. Had it been only a contractual dispute, the intention would not have been from the very inception to deceive the bank, because, my lord, as on date, the owner of the vehicle is the bank. Till date, my lord, they are not even surrendering the vehicle. If they have defaulted in the contractual obligations.
No, that is done. That is done already.
No, my lord. No, your lordship, absolutely not. They have taken back the vehicle and they are not wanting it to be subjected to the outcome of the contract.
Let us see the allegation.
Yes, your lordship. My lord.
Page 11. Come to page 11.
Please, your lordship, please.
That in consideration of the application of a request for a finance on a sale transfer vehicles, the complaint granted finance Complainant granted finance of rupees 18 lakhs to the accused on condition that the said amount is payable by 34 equal monthly installment of rupees 64,750. That in acknowledgement of the said terms, the accused, well, here the terms means the contract terms. The accused as a borrower executed a loan agreement, right, agreement number so and so, promising for liquidation of total dues along with other incidental charges as per terms of the said agreement. The accused became a borrower to the said loan transaction and gave assurance, promises and undertaking for strict compliance of this loan term and not to commit any breach of any terms of the agreement entered with the complainant relating to the said transaction at any event in future.
How many installment you paid? None.
Yes, how many? The three installment.
Thereafter you defaulted.
Default.
So the statement account says that 22 lakhs 95,000 rupees 169
Yes.
is payable.
Yes.
Come to para 5. In spite of the repeated demand, accused persons deliberately
and demand
false
the accused
assurances of payment of
deliberately get for substance
each of
of
them
payment on all substances and then knowing and intention without committed breach of the terms of the agreement and divided complainant legal use and unlawful lending out of illegal use of the vehicle in the hypothecation of the company. The manner the accused persons have received the complainant in routine way and defrauded.
Yes, I read it. Where is the statement? Where are the statements of preliminary statements recorded? No, 156.3.
156.
Direct 156.3. Thereafter. After where is the final form? Let us see
Final form.
what they got it.
Page 30.
Yes, come to page 17. During the investigation, to examination, took up documents for an investigation. I see the documents.
It's in a 30.
Like 30, 17.
Where is the cognizance order? Cognizance order is
The sequence find it. Page 18.
Next to 2.
Page 18.
Page 18. Next to 2.
Where is that? The order? Where does it say?
2 to 70.
Two?
Order dated 2nd February 7. 2 to 7.
Second paramile.
Got it?
See, that nothing is there. The accused,
Page
the record is put up today on something, I don't know.
Second paramile.
Page 18.
Where is second para?
Page 18.
Page 18, second paramile.
There is no second para here.
Pursued the affair.
Hard copy, hard copy there. Second para. Second para is not scanned.
That's scanning.
Page 18.
Yes, second para. Read it. Where is the FIR?
Yes.
Yes.
Page 18. Yes, statement of interests, and all the documents available there.
Yes.
There is branches, yes.
Yes, yes, Mr. Saurabh.
Your Lordship. My Lord, prima facie, the court does not have to go into the merits of the case. The court has gone into the prima facie evidences available on record, the charge sheet, the evidences under 161, and has come to a conclusion that a case is made out under 420-406. My lord, as
How, you see, this is a contractual matter, pure and simple contractual matter. In the complaint, you have not said a single word
my lord, may
about the
kindly-
criminality about it.
Yes, your lordship may
He
kindly
has
see.
paid 3 installment. 18 lakhs loan was granted towards purchasing a vehicle. Vehicle, 3 installment given. There are some defaults, and you have to proceed in accordance with law to recover the amount. How can you resort to arm twisting method of criminal prosecution against?
Your lordship is absolutely right. Had that been the only scenario of them entering only into a contract, my
Your
lord,
bank, you don't forget that you have many other statute to resort to. Surface
my lord,
high
bow
is there,
down. My lord, I
DRT
bow
is
down.
there, whatnot.
Yes, your lordship is absolutely right. My
And
lord,
you are financial institutions. You are not
Absolutely.
individual.
They have also taken blank checks.
yes, my lord, but that is never the case of the petitioner before your lordship. My lord, may kindly appreciate this. My lord, adds on date, the vehicle having not been paid the installments thereof. The specific case of the complainant, the bank and the financer is this, that they have illegally been using the vehicle as on date. They are not the owners of the vehicle. The Magma FinCorp judgment.
Now what is the amount due now?
My lord,
According to
as
you?
on, my lord, more than 20 lakhs?
No. On 10/3/2016, you said that the balance is 22 lakhs
22 lakhs.
95,000.
Indeed, your
Now,
lordship.
now,
The
now,
same
now it must
with
be
accruing
much
interest.
more than that.
Yes, with accruing interest, it is more than 25 lakhs, your lordship, bare minimum. Bare minimum, my lord, as on date, the interest, my lord, he has only paid 3 installments. My lord, may kindly look at the conduct of the party. My lord, the very intention to deceive the company.
I am not interested to go into conduct of the party. I am looking at the complaint which you have filed.
My lord, may kindly say
As per
paragraph
the
5.
complaint, it is pure and simple a contract matter.
No,
He
your
has
lordship.
taken
My lord,
loan defaulted.
my lord, I bow down. My lord, may
And
kindly say paragraph 5.
you are the bank who have given the loan to him. What is the collateral you have taken?
My lord, the vehicle, the vehicle is the hire purchase, the vehicle is the surety.
You recover.
Yes, yes.
What
My
was
lord,
the last order? What was the last order?
My lord, for a moment, kindly say paragraph 5. Just for a moment, my lord, what is the case of the complainant? What is the case of the financer? The case of the financer is this, that he has been using the vehicle illegally, because as on date, I am still the owner. Because he has not complied with the contractual terms and obligations, the Magma FinCorp judgment of the Honorable Apex Court is very clear. My lord, I being the financer, I am the owner of the
Complaint
vehicle.
doesn't say that.
I'm
Is
sorry,
it
my
theft or what?
my lord, the financer.
Has he taken the vehicle from your custody? He has purchased. He has
My lord,
not
he's
paid.
not giving it back. My lord, he ought to give it back. My lord, my specific case is this. My lord,
Show me
he
the
is
contract. Show me
Yes,
the contract.
my lord,
That
we have
if
filed
he
the
can't
agreement.
pay the amount, he has to give back the
Absolutely, my lord, we have filed that
Show me
agreement.
that.
My lord,
Show
we
me
have filed
that.
the agreement. My lord, may kindly see the clause. We have
Even
filed-
then, it's a contractual condition. You can ask for the performance of that. No criminal
My
case for
lord,
that.
my lord, may kindly appreciate this. My lord, may for a moment kindly appreciate this. My lord, the conduct of the
Show me the agreement.
my lord, we had filed the agreement. Is it there available for your lordships? We had filed the agreement on the last date, my lord, by memo.
Where is that? You initiated surface proceeding and
Surface proceedings have not been initiated, my lord. My lord, surface proceedings cannot be initiated against immovable properties. Against movable properties. This is a car that
you have
yes, my lord.
resorted.
My lord, that is wrong, my lord. My lord, with utmost respect, my lord. My lord,
That is the reason criminal proceeding. I understand.
Yes, my lord. My lord, with the utmost of respect to my learned senior appearing for the other side. No, my lord. Surface proceedings have not been initiated. Cannot be. Because this is a movable property, my lord. It's a vehicle that we're talking about.
I'm not here to advise you, but you know what to do in these
Absolutely,
cases.
your lordship.
You are the bank.
Absolutely, your lordship. My lord, that is why, my lord, we have instituted proceedings as available under law. My lord, just because it is a contractual obligation does not.
This is the difference. This is the difference between nationalized bank and private banks.
My lord, I bow down to your lordship. What is falling from your lordship is absolutely
Either
right.
either you pick up the vehicle without the notice, thereafter,
My lord, other litigations have to follow. My lord, we are doing it by law. Subject to your lordship's consideration.
where is the loan agreement?
My lord, we have filed it on the last date by way of a memo.
Loan agreement is not
Filed
there.
it, my lord.
Where is the loan agreement?
Yes, my lord, we have filed it in terms of the.
Petitioner, you have filed it on the page number 35.
And generally what happens is if the court directed to register FIR in 156(3) and
Your
the
lordship.
police generally reproduce the complaint and file the charge sheet without
Bow down,
application.
I bow down, my lord. My lord, this happens in a number of circumstances. My
In
lord,
no, in all cases.
my
in
lord,
all
I
cases.
bow down with the utmost of respect, but your lordship knows, my
They
lord.
just reproduce the complaint and file the charge sheet.
My lord, but
Recording
that has not happened in the
203,
present case.
161 statement and file it.
My lord, with the utmost of
The whole
humility and respect, my lord. My lord, this is my vehicle.
Please, do you have that copy of the agreement? Loan agreement?
Copy
filed it on the last
attached
occasion.
in page number 35, I think. Petition copy is not that.
Not petition, no, it's not there.
Nine. Oh.
No, no, no. I'm a court file करतुल again because of there was a direction from this.
Again, loan ନେଲା ବେଳକୁ ଆପଣ ଯୋଉ ପେପର ସାଇନ୍ କଲେ କରିଦେବେ। ତାପରେ default ହେଲା ପରେ ତାପରେ ଏଇ ସବୁ ଯାକ ଆରମ୍ଭ ଯୋଉ ସାଇନ୍ କରିଛନ୍ତି କାହିଁ ସେଇ ପେପର କାହିଁ? Your real case is from those papers. Where is that? Nothing is there. The hard copy is also there. It is also there. Nothing is there.
I'm sorry then, your lordship, my lord, we had filed on the last occasion by way
Counsel appearing for the bank seeks time to place on record the loan agreement and the other documents signed by the petitioner at the time of availing the loan. Release the matter next week though. I have heard enough. If you can make out a case on
Yes,
the
your
basis of
lordship.
those documents, is all right. Otherwise, I am going to quash it.
I bow down, your lordship, my lord, but be that as it may, my lord, just because your lordship has formed a
Next week, give it next week, 25th. Come with the document if you can't file. Huh?
I'll do that, your lordship. I'll do that. My lord, just
Entry mode to continue.
my lord, just
And think of taking some liberty to initiate some civil proceeding.
your lordship is very
Recover
kind.
your money.
My lord, your lordship is very kind, my lord, but just a very small submission, subject to your lordship's appreciation.
Yes.
My lord, just because there is a contractual obligation does not do away with the liabilities of criminal action.
That's the
That your
general
lordship
principle.
knows very, and your lordship
General
has.
principle.
Yes, my
But what is bothering me is, see the complaint, if you read the complaint,
lord.
no criminal case is made out.
My lord, paragraph 5. My lord, my case is limited to para 5.
Para 5, you only say he has defaulted. That
No.
doesn't mean that is a.
No,
Where
my
is
lord,
mens rea?
para 5 also says that he's illegally using my vehicle.
Oh, where is mens rea?
Yes, para 5, your lordship, my
See, no. See, I'll tell you. If the acquisition of the immovable property is valid, legally he has done it,
My lord.
and subsequent use can't be illegal.
My lord, the date.
He is not. This is not a property, immovable property.
Satisfy your lordship, my lord. I'll satisfy your lordship. I take down your lordship's query. My lord, because of magma of INCOP's judgment against Rajesh Tiwari, now, my lord, the law is absolutely well settled. Earlier, there was some discrepancy whether.
Okay, you bring.
I'll bow down, your lordship.
Yes.
My lord, 25th, your lordship is posting it?
25th.
82.
Pending and before your lordship, only trial is going on, your lordship, may I say your lordship, they have till the interim order.
82.
Yes, your lordship. The poor person in lordship appearing to legal aid.
Why do you ask for it?
Of the same reason for which the complaint has been filed by the complainant, for the very same reason, a civil suit has been pending before the civil judge senior division, unfortunately. So, taking the averment from the same suit, he has lost the complaint before the JMFC, unfortunately.
For a moment, you not say, but as well in this case, you not say, there's been petitioner transfer the property to her name, you not say. For a moment, you not say, kindly turn to the complaint portion.
But in any case, he is asking for time. I'll give a short date. Entry mortar. We'll see how much. Entry mortar to continue. That is the only reason entry mortar. I'm not granting entry mortar. Once entry mortar is granted, then always adjournment. And this will keep on pending for years and years and years. Better that if you have merit,
Repeat again and again adjourn.
Short date you say 110 meters. What? How can I quote accommodate? Anyway, 30. You don't have a copy.
No.
You are arguing the matter.
Only the complaint bits of yours.
Give a copy.
Because of this is a truly legal.
Give entire set. The Compoundable Petitioner undertake to furnish the entire paperwork of the present case to the part of the. Yes.
83. My lord. The matter is listed for hearing, my lord.
Don't come in between. Maintain some decorum. Don't come in. Yes. Yes.
The matter is listed for today, my lord.
Yes.
In the previous order, despite the service of the notice, nobody appears. Also, the matter is listed for today.
The opposite party is complete, despite the notice, nobody appeared. What is this matter is about, ma'am?
The facts of the case is that the petitioner has filed an application under section 12 of PWDB Act against the OP bearing criminal miscase number 28/19 before the court of STGM Rourkela, praying monetary relief and other reliefs. And in the said case, she has also filed an affidavit under section 23(2) of PWDB Act, praying for an ad interim monetary relief, and annexure 1 is the said copy of the petition under section 12 of PWDB Act. Sir, on 16th February 2019, Learned STGM has
What happened on 15/4/2021? You tell me.
Yes. On 15/4/2021, the impugned order.
What is this impugned order?
Sir,
You are agreed by what?
yes, sir. In this impugned order, the Learned Appellate Court has wrongly held that the petitioner is stopped from claiming any maintenance from the OP since the date of order, that is 16th February 2019, since up to 16th October 2019, which is the date of decree of divorce. Sir, he is limited the amount of the maintenance, the amount of maintenance, the paying up amount of maintenance from the date of order up to the date of decree of divorce. Sir, the right of maintenance.
Date of
the date of order, that is 16th February 2019, up to the date of decree of divorce, that is 16th October 2019, sir.
16 October 2019.
19.
Okay.
So during the proceedings of the DV case, a decree of divorce by mutual consent, white order dated 16th October 2019 of Learned Family Judge Rourkela in CP number 69/2019 has been passed. And therefore, he is limiting the order of maintenance up to the order of decree of divorce passed by the Learned Judge Family Court Rourkela.
You are talking about 8 months difference.
I am filing of the execution case up to 22 months, my lord. But he is limiting my maintenance, order of maintenance up to the decree of divorce. That is 16th October 2019.
And you want up till?
Sir, actually, sir, for this impugned order, sir, where the main order, that is the 16th February 2019 is intact and has attained its finality, but I am getting no single pie from the OP during this impugned order.
What is the amount awarded to you?
Sir, the amount is pending.
20,000.
The amount is pending since 16th February 2019 till today, sir. Only I have received rupees 80,000. Only I have received rupees 56,000, sir.
Is there any criminal case pending?
Yes, sir. Yes, sir. GR case is pending, sir.
GR case is pending.
Yes, sir.
You give me the particulars of GR case. See, unless you bring your husband to this, appear in this court, who will pay you? Even if I pass the order, the same thing will happen. Let him come so that.
They have the knowledge, sir, since 9th February 2023 about
What
this
is
case,
the,
sir.
Madam, what is the fun in getting an order on paper if it's not executed in a matrimonial dispute? Eventually, he has to pay you. These are the maintenance. Give me the GR case police station so that I can ask the police station to serve the copy.
So that is GR number 1866 by 2020.
PS police station.
Mahila PS Raurkela.
Mahila. Yes, Mr. Yes, Rahul.
Mahila police station.
Service on the because there is case pending.
Yes,
Mahila PS case is pending. GR case number
1866 by 2020.
1866.
Yes, sir.
20.
Again, 20, sir.
Madam, opposite party.
PS case number.
PS case number, just give me. You
Sir.
have?
Sir,
PS
sir.
case.
PS case number that is 16 of 2020, sir.
Mahila PS case number.
Yes, sir.
Mahila PS case number 16.
Yes, 16 of 2020.
20. Raulkela.
Yes, sir.
Right now. Opposite party number 2 is an accused in PS Mahila PS case number 16 of 20. At Raulkela.
My lord, he has every knowledge about this case, sir. He has every knowledge about this case. And intentionally he is avoiding to.
1 minute, madam. And will you take Dasti and serve?
Listen, please.
Then wait, I am trying to. Yes. The notice in the present case notice was directed to be served on the opposite party number 2. However, despite notice, he has not appeared in this matter. Therefore, the matter was adjourned on 20/18/2024. Let the notice of the present petition be served on the opposite party number 2 through the IIC Mahila PS Raulkela. Raulkela. The additional, you need the copy, na? You need 2 copies.
Yes, I am in need.
Let the petitioner find 2 additional copies of the paperwork within 1 week, and reach the matter also. And you file additional copy so that we'll try to serve the opposite party number 2 through the police.
Kindly provide the date, sir.
Yes. Next.
84.
Adjourn. Yes. Adjourn.
85.
80.
54.
We'll place it. I am adjourning because at this moment, who will ask? Yes. 85. 85. Yes.
This is a challenges the order dated February 23 in a protest petition after final form submission, the allegation was disproved, challenge occurrence thereafter the protest petition filed and a cognizance has been taken. Initially, the case has registered 341-294.
And show me the protest petition and the evidence.
I think the answer 4 is the protest petition in the
Yes.
at page 90.
What are the allegations?
Allegation same allegation. What are the allegation in the FIR that has been alleged in the complaint petition page 18?
Where are the evidence statements and 202?
202.
No. Not.
No. Find those evidences, then only.
But you have challenged cognizance.
No.
That copy also annexure 5 did not serve to state.
Annexure no, annexure still 4 minutes.
Till 4. All right.
No. See, your case is protest petition is filed and evidence was recorded and thereafter cognizance is taken. You are challenging that cognizance. Where is those statement?
I will find the statement.
Let the counsel for the petitioner seeks time to file the statement recorded by the court below Under section 202 CRPC, please the matter. Yes.
Interim order to continue.
Interim order to continue.
86. I'm challenging the pending look at my prayer. The police matter submitted the justice matter ignoring the section 376 to end matter, though there is matter. That section is clearly made out on the basis of the.
Who are you? You are the.
I am the informant.
Adding the cognizance 376 to N. Adding the.
The Lordship kindly see page 9. That is ଗ୍ରାହକର ପ୍ରଲୋଭନ ଦେଖାଇ ମୋ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ଦିଲ୍ଲୀପ ସ୍ଥାନ ମୋ ସହ ବାରମ୍ବାର କାର୍ଯ୍ୟ This is the FR story and all these other statement and other matter. There is.
What cognizance is taken under?
The police submitted charge under section 417, 332, 354.
493 is also taken. 493 is also taken. What is 376? How?
Because of the rape matter. He committed rape matter.
Where is it? There is. What is the how much delay in filing FIR? Delay when this so-called 376 is made out, when you filed? Continuously. On Ichha continuously things were going on. You didn't go to the police. After she refused to marry, you go to the police. And 376. Leave him. Leave him here. 493 is there and other offences are there. He will face it. And persuade him to marry. That is a better idea.
Now, because of that, there is issue. He will not marry.
Yes.
87.
Yeah. My challenge is the order passed by the learned magistrate on an application under section 127 of CRPC.
Annex 3. Impugn order.
Yes, no, the impugned order is this order under Annex
8.
3 and 8. 8 is the revisional order. I went in revision against the order under Annex 3.
Yes.
And that revision application has been dismissed, therefore I am issuing a lawsuit. But here my sum and substance of challenge is, my lord, the wife, my lord, is not entitled to any maintenance in view of the fact that she has voluntarily, without any reasonable cause, has deserted the husband, which is
withdrew from your company.
Yes.
So therefore,
there is a decree, your lordship kindly have a glance at Annex 1. The decree passed by a civil court.
Anyway, it is for maintenance, na?
Yes.
So
Enhancement of maintenance.
Notice was issued.
Notices they are appealing.
No more open because of the fact the 125 petition was filed that has been allowed. Regularly paying the maintenance at the rate of mother 2000 and the son 2000, 4000. That is in 2014 order was filed. Then 127 petition was filed by the wife. Now I am unable to maintain myself, therefore it may be enhanced to 15,000. Both the courts below, taking into consideration, he is a constable, he is getting his salary at the relevant point of time, 46,000, and fixed the maintenance for wife 6,000, for son 4,000. And the magistrate fixed that same amount, and in revision that has been confirmed. His pay slip has been attached. It has been proved.
What he says is, in the main order when it was passed, you did not take that plea. In the enhancement, you are taking all this plea. That's what he says. Now, why in the main petition, when the main maintenance order was passed against you, 2000, have you taken that plea?
Then the matter was sub judice in appeal, madam. They had filed an appeal that was sub judice before the honorable court. The suit was filed, suit was decreed in my favor, holding that the wife has for no reasonable cause has deserted the husband, therefore decree has been passed. That was challenged in appeal. Appeal was dismissed.
On the ground of desertion.
Yes.
Yes.
Appeal was dismissed. Thereafter, they preferred a second appeal. Second appeal was also dismissed. Now, your lordship may kindly, even my lord, my learned senior, what he is taking a stand that my lord, because I was staying there, I am prevented from taking that plea at the present juncture. But your lordship may kindly come to section 120.
Yes, read
I will
it.
satisfy your lordship that there is a possible chance to subsequently, my lord, the
What happened to
magistrate can recall that.
what happened to the divorce? Divorce has already been
Yes,
finalized.
divorce is already granted. I am already married and I am having 2 children at present. My lord,
Absolutely no prayer. Absolutely no prayer. Your lordship may kindly have a glance at it. The prayer he made, he wants to challenge the enhancement. Your lordship, at page 30, the petitioner therefore most humbly prays that this honorable court may be graciously pleased to admit this application, comfort the LCR, upon hearing the pleased to be pleased, pass the impugned order under Annex 3 and the judgment passed by the learned additional session that
Enhancement. He has challenged enhancement order.
Enhancement order. Challenging the enhancement order. Enhancement order means, my lord, there could not have been any enhancement. Rather, the magistrate would have recalled the order of maintenance. Your lordship,
Have you moved such application?
125(5), your lordship.
Yes.
4 and 5 are clear. Section 4 says, my lord. Subsection 4, 125.
Yes.
No wife shall be entitled to receive, your lordship got it. No wife shall be entitled to receive an allowance for maintenance or the interim maintenance and expenses of proceeding, as the case may be, from her husband under this section, if she is living in adultery or if, without any sufficient reason, she refuses to live with her husband, or if they are living separately by mutual consent. Now, your lordship may kindly come to section 5.
Without any sufficient reason, he refuses to live with her husband.
Yes.
No more husband now.
No more husband, my lord, because decree has been passed on that ground only. My lord, she has for no
Deserted.
cause she has deserted the husband, my lord. And that has been confirmed in both the appeals, my lord. Now, your lordship may kindly come to subsection 5. On proof that any wife in whose favor an order has been made
Under this section.
under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. So here I am, my lord. My lord, if it comes to the knowledge of the court below, and I am able to prove that she has refused to, my lord.
Will it cover even after divorce?
Yes.
No,
Because
it says without sufficient reasons refuse to live with her husband. That question goes only had it been a section 9 decree, I can understand. And that they are living separately by mutual consent. That is also not a situation.
That is not the situation.
And now a decree is passed, direct final decree is passed. So therefore, 5, how will you cover 5?
So cover 5 means, my lord, here an order was already there granting maintenance in favor of the wife.
In 2 conditions, existing order can be recalled.
Existing order can be recalled.
One condition, first condition is if for sufficient reason refuse to live with her husband. That means if a maintenance order is passed and section 9 decree is there, and even then you are not joining the company, then in that situation 25 order is recorded.
That is not my lord specifically said, my lord. If she refuses,
That would be a situation. Second is, and now will you after decree of divorce she can't come and stay with you.
No.
Where is the question of refusing to leave?
At the time of granting of maintenance, my lord, because the matter was sub judice before the court, my lord, therefore maintenance was granted. Subsequently, my lord, in the second appeal that has been dismissed, giving the finality to the order passed by the learned magistrate, learned civil court, under section 13. So, section 13 has come to its finality.
I know.
after dismissal of the second opinion.
Where is your application for his enhancement application and your objection?
That what I have filed, my lord.
Where is the objection? Have you taken all these objections?
Yes, my lord. I have that the lord, court below has discussed regarding this. Your lordship may kindly come to page 45. DP. I have specifically stated and filed the copies of the decree passed by the civil court as well as the appeal judgment that has been discussed in paragraph 3. Your lordship.
Now it is enhanced to what? 2002 enhanced to 50.
4,000 or 10,000. So far as son is concerned, I am not disputing. My lord. Son, I will pay.
You are married.
But as long as he is a minor, I will pay as per section 129.
Say, how much? How much? 10,000 rupees.
4,000.
Son 4,000 rupees.
Son, 4,000.
Husband, wife 10,000.
Liable to pay anything
10,000.
because of this decree passed by the civil court, which has got its finality by final judgment by final order.
Any permanent alimony? Any permanent alimony granted?
No. Nah. So
You tell me how much.
Permanent alimony.
1 minute. How much lump sum you will pay? Finish it up.
Lump sum.
Pay lump sum and finish it up.
It is a alimony entitled to it because
I am not on legal issue. Offer something, pay and finish up. And this litigation will lead.
I would just be the constable. He is to maintain his two children and the wife.
The present salary I have.
And
Not by RTI.
And he is married with 2 children.
76,000.
Married with 2 children.
Already married and.
You seek instruction how much in one go you will pay. Well, see, the fact of the matter is you are married, you have children, but this lady might not have married.
No, actually,
There is a child. 4,000 rupees. How?
He is a private job.
No,
He is earning around 10,000 rupees per month.
Not correct.
That is my instruction. See, he will definitely say it is not
What
correct because
There is no whisper in the.
What is the educational qualification you have?
Getting 12 parties. That's not educated.
Multiple, perhaps let them disclose it by filing an application.
No, but without going into that, my suggestion would be you offer something as a permanent maintenance kind of situation. Let us give something and so that the child and the mother and son, after all, the child is yours. 4,000 rupees what?
And your lordship will kindly look at the conduct of the wife also.
Then I'll do one thing then. I'll increase the maintenance of son to 10,000 rupees and I'll say the wife is not entitled. So then you find out some way. See, you have created that situation by marrying a second wife.
After the divorce.
Whatever.
After the divorce was granted and it attended the finality manner, thereafter I married.
But
I have to lead my life.
you can very well seek instruction, one-time settlement, give it and finish it. I pass some order, he will go to the other court, you will also go to other court, keep on fighting. In that process, you end up spending more money.
Law permits something, my lord, I have no hesitation.
I am not on law now. I am not on law only. Because if you keep on fighting in this process, you will end up spending more. So therefore, after all, she was your wife. And the maintenance, according to me, maintenance of 4,000 rupees.
How she has, my lord, the evidence has come and how she has left my.
Maybe I am not on that. Maintenance of 4,000 rupees to the son is very low.
More than 30,000 more than what they are saying.
What is the age of
Now
the
he is
child?
getting
Wait,
76,000.
age of that boy? Boy,
He
yes.
is reading in high school.
She is now 16 plus. My lord, he can get up to 18 years, not beyond that.
And this lady?
Lady, my lord, you are, my lord, in view of the law of the land, my lord, she is not entitled to any maintenance.
No. Suppose it goes against you. Original maintenance is maintained. Then she will be getting It is kind of a family pension.
4,500.
It is kind of
So
a family pension.
that is why I was not challenging because my son is there, man. Bona fidely, I was paying the money.
So
because it was
it is not well advised on your part to contest it and offer how much you want to pay. We'll finish it up. Even if enhancement, I will set aside the enhancement. The original amount you will have to keep on paying throughout your life.
4,000.
But throughout your life, you don't know. And
Throughout the life, after 18.
Wife.
Wife to buy up entitled.
Entitled life, I will held entitled. No, you come with an offer. We will finish it up. Come with it. And legally deciding, see in the main this thing that time appeal was pending, of course, but there was a decree.
And they have taken much more amount than what was directed to be paid because my lord, your lordship will find my lord in a previous case. Well, just 1 second.
Absolutely false statement. Don't tell those. When in the other proceeding, the court wanted you give a affidavit, how much amount is not paid to the wife. Then he withdraw the case.
No, I withdraw because
I don't want to go into all these things. Lease the matter on 26th of this month. In the meanwhile, Mr. Mishra would seek instruction to settle the dispute by paying one-time maintenance to the opposite party number 2.
1 and 2. No, the opposite party number 1 and 2.
1 and 2. One-time maintenance. First we could. You get instruction and pay once so that their life is settled. You can avail loan, your police constable, you can arrange the money. No problem. Yes.
88.
Interim order to continue.
Yeah, interim order. Yes.
302 trial has been stayed. Going on adjourning the matter 302.
88, huh?
88.
Short date is.
Amar quietly adjourn kare.
Yes. 89.
89.
Adjourn. 90.
90.
Yes. Who is appearing for opposite party? The service.
এটা হচ্ছে 91 না
91.
91 नहीं ତାକୁ କୁହାଇଥିଲେ ସେ 6% ଇଣ୍ଟରେଷ୍ଟ ରେ ଆମାଉଣ୍ଟ ନେଇକି ଆସିବେ 22 ଲାଖ 90
अच्छा
এটা হবে এটা ইউনিয়ন অফ
Yes, service not complete.
No, madam.
Huh?
No,
Awaiting service. Urgent.
Government madam. Both parties are government parties. Copy of
service was
the union of India
item 91.
Issue notice to the opposite party, PK party, deputy.
Yes, PK party, union of
India.
None appears for opposite party number 2. Urgent to such interim order to continue. Yes.
91.
Lordship, on the matter has been settled. Prayed for an adjournment. I have not arranged the money. The petty 22 lakhs has not arranged.
Next week. Next week.
Next week. I am for the opposite party. My lord, they are telling that the matter has been settled. There no information has yet come to me, your lordships. Kindly, those they are telling. They're telling anything. What are they telling? They're a false statement. They are telling. Kindly have a glance, my lord. By telling such false, vexatious statement, they have on.
Yes, Mr. Mahapatra, whether matter is settled or not, he is disputing.
No instruction come to me till then.
His client should have to provide instruction to him. So I am not supposed to provide any instruction. What I have obtained the instruction from my client.
You, Mr. Das, you seek instruction from your client whether they settle or dispute.
I am the opposite party, man. I have obtained loan and given them money 22 lakhs for purchase of this house. They are not coming to me. They are only telling settlement. What settlement? I don't know. That what are the today latest by 3 p.m. I have obtained instruction that they have not come to me. No instruction are given to them. They are only telling settlement. What settlement, your lordship?
They want to see the color, Mr. Mahapatra, they want to see the color of the note, that's all. First pay the money, then settlement. Merely saying that settlement is not settlement.
Last week, as per they have told that they want to make settlement.
Okay.
Lordship, hold the view that they have to pay.
Okay, adjourn it to next week, let us see. Yes.
Lordship, noting may be made that whatever the settlement they want to make, unless
92, na?
92.
92.
92.
You just see opposite party too. 92. Nobody appears. Despite service of notice, therefore.
This matter is similar, the part similar to 87, Mr. Mishra. I am all around to take my wife and
Service complete, but nobody appears.
Despite service, none appears for opposite party. In the interest of justice, urgent to next time for me. Date 93.
93.
So 93 minus. Last petition, the Lordship directed my non-stand to take instruction, and there is a release of the amount which is seized by the police.
Yes, any instruction is there?
No, I have not received any instruction. You also may.
I have also
on
taken instruction
26.
of the last petition and I will give the property security to that extent, 1 lakh somewhat for release of the amount. That is the grocery shop amount, madam.
Yes.
I will give the property security and take the amount.
The cash security you want to, the cash seized from him. He wants to utilize that cash by furnishing,
Property security.
Please see it next week. By next week. Next week. We will.
After completion of investigation, it can only be accepted that the amount was.
No, I understand it. See, some money was seized from him. And he applied under 457. And the court says that after completion I will pay. He is a grocery shop person, he want to utilize that money, give him. Property security, you take it.
Yes. 2 lakhs, 1,27,375.
I am allowing it.
The Lordship property security.
Where is that application? Where is that order? Impugn order.
Next 4.
Right. The application moved by the petitioner under section 457,
Sorry.
Huh?
457.
457.
457. Page 23.
Page 25 is the operating.
For release of
Cash amounting to
cash amount, seized cash amount of rupees
1,25,375.
has been
Page 25 is the operating.
has been rejected by the court below by impugn order. Entry alia stating paragraph. Impugn order को paragraph.
Impugn order paragraph.
Page 25.
Para 5.
Middle portion.
Para 5.
Para 5.
After completion of
Entry alia stating as under. Para 5 आपको दीजिए. Page 24 start होची para 5. मुझे देखिए. और सी portion to highlight कर दो. After completion highlight करो. After completion आपको investigation, it can only be ascertained amount shown. तब highlight कर दो. ठीक है? कर दो. Then counsel of the petitioner submits that the cash amount of 1 lakh so may be released in his favor on furnishing the property security for the said amount. The amount of so is directed to be released subject to the petitioner furnishing property security of 1,50,000 rupees. 1,50,000 rupees. Property security is 1 lakh. ठीक है. Allowed. चलो.
96.
My lord, this matter is head for the mediation and because it is the matrimonial cases.
Yes. What happened?
I'm challenging the order of the
Mediation.
Mediation पे challenge.
Mediation.
It is shown that
The opposite party wife has appeared, but today is not here.
Where is he?
Mr. Das Karyar is appeared.
30th, Tirish. Yes.
97.
97, my lord, I am on VC, my lord.
We'll see 30th.
Execution.
Opposite side notice has been issued, nobody is there. Last time appeared.
Showing in the.
Wait, at this stage, the last hour, don't, without application of mind, I will not do it. Don't make it so. No entry order now. After 4 o'clock, no entry order. Hurriedly, I will do something, then somebody will come and move an application. Why? Yes.
97, I am on.
Allowed, I can think of. Yes. Nobody is there.
97, I am on VC, my lord.
Yes.
My lord, the alleged offences are under section 447, 379.
No question of arguing now. If shortcut, if you have anything, this help me. Opposite number 4. Notice.
My lord, allegation is that the present petitioner are.
Wait. Opposite party number 4 notice has been served or not? No.
Yes, sir.
On 19/3/2024, huh?
Service sufficient.
Nobody
appeared.
Despite due service on respondent number 4, none appears in the interest of the CSHJ. Yes, next.
Next revision matters.
Revision matters we will not take up now. Roll over. Yes, sir. आप लोगों को मैटर थे ना पास आउट
58.
हाँ ठीक है एंड हाँ देख लीजिए दे दो डेट सारा से तो सेटिंग कर दीजिए आप लोग देखिए कि नहीं जी डेट there is a meeting now because your bar association newly elected people will come and meet. Okay.